40.
Serial number 48.
Why 230?
Senior will be appearing.
We'll take
My
it.
lord,
Wait,
in serial number
when it
48.
reaches, we'll take it.
But
When it reaches, we'll take it.
My lord, in serial number 48.
What is it about?
it is about the construction, the illegal construction is going on from the
We'll take
residence.
it will reach. Don't worry. Yes.
Please, my lord.
My lord, serial number 45.
Yes,
my
Mr.
lord.
Yes.
One matter for posting tomorrow, please, ma'am. New matter, not post.
It will be posted. You remove the office
It
object.
appeal, please, my lord.
Remove the office object.
My lord. For our complaints of office objections, they are asking me to post, get the matter be posted.
Remove the office objections.
Yes, sir. For removing the office objections, time is not there.
IA.
Which time and
You move IA.
Please.
Move IA. Yes.
Serial number 42. Each may be given.
42.
Applied.
42. For weeks time.
42.
20th March, 20th
yeah,
August.
Number 678.
Serial number?
678.
678. What do you?
Withdrawal. I'm filing
6, 7 and 8. Separate orders, same order, but same. Learned Derogation Shivalli, Shivayogi, Yellappa Goda states that the writ petition has become infectious. He tenders memo of withdrawal.
Yes.
Paragraph. He tenders memo of
Similar
withdrawal.
petitions are
Date
disputed
30,
with
7,
law.
24, which is taken on record. Full stop. The memo reads as under, and quote the memo.
Not in
Dedicated portion. Petition is dismissed as infectious. Accordingly, the petition is dismissed. In all three, same.
My lordship, one memo for education matter, my lordship. Its case is pending. I have filed an IA for direction. The examinations are starting from 9th of August, my lordship. This honorable court has granted to take examinations for the last year and he has failed and the examinations are starting, my lordship. For day after tomorrow,
5th August.
day after tomorrow, my lordship.
Yeah.
Grateful, my lordship.
One second. Yes, Mr. Yes,
16 months. Serial number
16.
weeks and
What do you want? Time.
weeks and may be given.
It will go to 19th August
60th. 60th.
at the request of learned Derogation. You are for respondent.
I'm so sorry.
Priyanka Yagal, stand also 19.
Lordship,
One matter for preliminary. I am for the caveat, a labor matter. The direction to implement the 2013 Welfare Act for the daily wages, my lord. Till date, they have not implemented, they have not removed the office objections also. I am for the caveat. Some emergency workers are something, almost 70 workers are involved.
Yeah, they will move. If they are interested, they will move.
Lord,
How can you?
Madam Lord, I have filed an application for early listing of the matter, Lord. So now the matter is posted on 26/9. The matter was listed before the coordinate bench, Lord. I am requesting not to be earlier date. Lord.
You file IA
I have filed a. I have filed a.
for preponement.
Yes, sir.
Get it list. 5th.
lordship,
Great.
IA to be listed on 5th.
Memo for posting, lordship. 20 days back, it was posted for office complaint
Want to
before
make-
registrar.
Memo for posting, the pollution board had issued a letter to the deputy commissioner of collection of penalty for 1 crore, your lordship. They're coming just now out of insolvency without any violations, have imposed a ridiculous amount of penalty on us, your lordship. We pray that it may be posted for order, your lordship.
It will be listed. Remove the office of,
Or no office objections are there.
then 20th August.
Your lordship, shorted 5th or 6th. The
8th.
Lordship, contempt matter, memo for posting, Lordship. It was listed before register 20 days back. I have complied with all the office objection. It may be posted.
20th August.
Little earlier, my lordship.
No urgency.
Matter relates to
Your Lordship, serial number 4, my lords, short accommodations, as the senior is not well, my lords. Short accommodations,
4.
the serial number 4.
No. Yes.
my lord, serial number 39.
39.
It was directed to be posted along with WP 14905.
That this has been decided by the Constitutional Bench of Apex Court, Lord. Tax and royalty. Day before yesterday, it has now decided by the Apex Court.
Pardon?
Tax and royalty. This is a matter pertaining to tax and royalty decided by the Constitutional Bench.
Oh, so time.
Now they are seeking time, sir.
On last occasion, it was directed to be posted along with WP 14905 of 22. Your
Now that judgment we would consider.
uh,
This may not survive in view of that judgment.
But there are other grounds urged in the writ petition, Your Lordship.
13th. 13th August.
Lord, serial number 17.
Transfer of register evaluation where government has exercised doctrine of pleasure, my lords. Not a single judge has interfered with it on the ground of coordinate bench decision, my lords. It was not an appointment, it was a deputation and repatriation, my lords, but even then, a coordinate bench decision is relied upon. So I'm moving a memo, my lords. The matter is not getting auto listed. That is the reason I'm moving, my lords, moving the memo, my lords. All the office objection, everything is complied, my lords.
When it was filed.
2 weeks before, my lords.
Take it up 6th of August.
Much of it.
Lord, serial number 17, my lord. I need an adjournment. My senior is not well.
19.
17.
17.
Yes, your.
At the request of learned advocate for the appellants, turned over to 27th August.
Much.
List 2, serial number 1. Shrikant MP.
Petitioner,
For this one.
Respond number 13.
the petitioner, my lords, she is, my lords, international event winner, my lords, chess game. She won, my lords, the medal at the Asian Youth Championship. She approached this honorable court, my lords, initially, my lords, by filing this petition for the year 2023, my lords. Her contention was that she participated, my lords, she represented India, sponsored by, my lords, Chess Federation. And as such, my lords, as per Rule 9(1)(b), my lords, of the relevant rules, as she represented India and, my lords, secured the medal at an international event, she should have been classified as P1, my lords, as per the classification. But unfortunately, she was classified as P5. She was apprehending that she will lose a seat. And as such, my lords, for appropriate directions, she approached this honorable court.
Yes, sir. Your prayer is for consideration of revision.
Yes, my lord, that at that time, my lords, definitely yes. But later on, my lords, after the writ petition was filed, my lords, for some time, my lords, no objections were filed by the respective parties, that is, my lords, KE and the state. Even till this day, my lord, the state has not filed the objections. Lords, in the meanwhile, what has happened, lords, is that, lords, the 23 selection, lords, admissions got over. Lords, as I had no other option, I had to take a payment seat, my lords, in so far as 23 is concerned, that is in a medical college. Fact remains that, my lords, I am entitled for government seat. My lords, as such, my lords, I had implemented, my lords, the other selected and admitted candidates, my lords, in the petition as party respondents. The prayer is, my lords, if, my lords, in other cases, earlier cases, my lords, this honorable court, my lords, directed redoing of list. My lords, for a moment, my lords, if no one's seat is also, my lord, disturbed. If they rework, my lords, I'll be entitled for, my lords, a seat in medical college, my lords, according to my ranking, my lords, in the preferential list. That can be adjusted, my lords, for this academic year, my lord, there should not be any difficulty. In fact, my lord, that issue, my lords, is covered by your lordships.
Number 13 was also P1.
My lord, P1, if I'm permitted, my lords.
So then
All
how-
the,
On what ground you are challenging?
my lords, my case is that, my lords, I am an international medal winner. My lords,
The candidate who was given admission was at the
Please.
same pedestal.
it may not be so, my lords. I'll be the only P1.
He was categorized as P1 or not?
No, my lords. There was no P1. There only P4 and P5, my lords. There is,
P5.
I was categorized as P5, which I said is not correct.
No, 13, number 13. Who was admitted?
I have produced, my lords, annexure M, the ranking list, my lords.
I have produced annexure R1. I also produced the sequence of events, my lord, with regard to who's ranked, my lord, page 6 of my statement of objection. Yes. The government given, my lord, this has been given by, my lord, the state government. In the sense, my lord, the Department of Youth Services. As per this, we have done the selection. According to the department, my lord, he is at P5. Now he says I should have been considered as P1 or P2 or P3. At this juncture, my lord,
Even if your lordships kindly take, my lords, their objection annexure 1, they are P2 and P4, my lords, no one in P1. Page number 6, my lords, of account.
P3 awarded.
respond number 13 is P3.
But no P1. I'll go on, my lords, on top.
He now says his categorization itself is wrong. That my lord,
Who are respond number 7, 9, 8, 11 and 12?
All those, my lord, there'll be 7 seats, my lords, for inter sports quota.
They are students
All the students, my lords,
completed.
subsequently pleaded.
they have been included subsequently.
You have filed your reply?
Yes, sir.
Where is that? Where is your reply?
My lord, that was filed on, my lord. 26th of July.
25th of July. 16th July, no, 25th July.
The respond number 1.
My lord, they put the onus on the government.
I give a copy, my lord?
Yes, 16th July. Until 19.
Madam, consider presentation.
Consider on Monday.
Please.
That is for previous academy.
It is necessary for the government to. It is necessary the government to file a statement in this case, because the categorization is done by them. You have to justify the categorization.
By government.
Government.
Will file
Is not.
Government has not.
learned additional government advocate. Says that he may be permitted to file. Reply come statement of objection. Same may be filed before the next day, stand over to 19th of August.
Please.
Number 2, the Sagar BB.
Petition.
Is a physically handicapped photometer, locomotor disability.
You are for MBBS.
Minutes, yes, minutes. Minutes, the petitioner has applied minutes for MBBS and minutes dental under SC PWD quota minutes, person with disabilities. Minutes, the committee minutes has assessed my disability minutes at 50%. Minutes, the relevant guidelines minutes says that minutes between 40 and 80% minutes candidates.
Guideline.
Minutes have annexed it to the petition minutes. Page 31 minutes.
In the act also provision is there.
Minutes. Even in the act also there is a provision.
Act of Persons with Disabilities Act.
Yes, ma'am.
2016.
This has to be seen along with Annex D. The disability, as far as medical is concerned, my lord, disability is assessed, my lord, by the, there is a regulation made by the NMC. That is at page 30, Annex D. For medical, my lord, we have to, engineering is eligible, have made him eligible. As far as medical is concerned, my lord, the committee said he is not eligible. Lordship got it, Annex D, my lord, page 30. 31 is that is the first column. Down below there is a column. Locomotor disability, including specified disabilities A to F. He comes under others such as amputation, polymyelitis, etc. That should go along with my lord, ostrich 3 down there.
So 40 to 80 disabilities.
Yes, but that should go along with, my lord, the ostrich 3. The 3 stars are there, my lord. Annex F, your lordship got it, right? F.
Both hands intact with instinct sensations, intact sensations.
Both hands intact, yes, my lord. And this is what the committee has, the board, lordship, have the 4 doctors who have signed. No, they say it is 50%, but he is ineligible. Because, my lord, the, I'm sorry, my lord, it's, that's serial number 5, my lord, is the petitioner. I have given a reason, point specific.
Where it is, which board it is.
5. Nature of disability. Not the post-septic, circulate, shoulder, upper elbow. There is a weakness in the upper elbow. And they have made
Shortening.
shortening. The shortening of upper elbow, weakness of
Upper limb.
elbow. Upper limb, yes. And they made him give 50%, but they made him eligible for the engineering and nursing, made him not eligible for medical PH, and they made not eligible for veterinary PH.
Both hands intact. There is a shortening of the limb.
Yes. That is both hands intact. Here there is a shortening of a limb. That's the reason perhaps, my lord, the ostrich, my lord, both hands intact with intact sensation, sufficient strength and range of motion are essential to be considered eligible for medical course. Like in the previous matter, my lord, if lordships want to have a relook, my lord, lordship direct, my lord.
Lords, insofar as, my lords, assessment by the committee, my lords, Supreme Court has held that, my lords, detailed reasoning, my lords, will have to be given. My lords, assessment, my lords.
So your hands are amputated.
It is not amputated, my lords. It is not amputated. My lords, both my hands, my lords, are intact.
So then how does the falls in this 3-star category?
My lords, I am not furnished, my lords, with the, even before filing of the writ petition, my lords, I had sought for the opinion of the committee. My lords, that by way of representation, my lords, it was not furnished.
Sorry, my lord, I missed it.
My lords, the disability, my lords, is to be assessed, my lords, on 2 counts, my lords. One, my lords, is the quantitative assessment of the disability, and the other, my lords, qualitative assessment. My lords, the assessment, my lords, what now it appears, my lords, prima facie, it appears that, my lords, it is only a quantitative.
How could the categorized in star three, both the ends intact. How?
That's why they have categorized as not eligible.
No, he is falling in others, F, A, B, C, D, F.
Yeah, but-
Others such as amputation, polymyelitis, etc.
Yes.
So he is falling in this category. How?
No, I am not able, it's not.
So how do we,
Milords,
how
if I
do you
may
say
pass
that
on the
these
judgment.
criteria will apply beyond 40 to beyond 80%?
Yeah, when 50, when assessed as 50 to 80 may not,
Milords,
is,
for the- for the-
40 to
for-
80.
for that,
What is your disability nature?
Milords, there is a disability, Milords, in the shoulder, Milords. It has nothing to do with, Milords, the strength of the fist, Milords. Now, Milords, for any candidate, Milords, to be eligible, Milords, to pursue medical course, Milords, the committee, Milords, will have to assess, Milords, whether, Milords, the clasp of the fist, Milords, whether it is strong enough, Milords, to, Milords, hold on to, Milords, the medical equipments. Milords, that, Milords, is the, that was the required assessment, Milords, that was to be done by the committee. Now, the committee, Milords, there is a deformity, Milords, there is a, in medical terms, Milords, it is a disability in the shoulder. The rest of the hand, Milords, is intact. The other disability is, Milords, the one hand, Milords, is shorter than the other. But, Milords, that itself, Milords, would not, Milords, prevent me from pursuing, Milords, medical course. The strength in the clasp of the strength, Milords, in the wrist, Milords, to hold on to, Milords, the medical equipment, Milords, is good enough. Now, the committee, Milords, that has assessed my disability, Milords, 50%, Milords, that is the Milords, quantitative disability. But, Milords, Supreme Court says that, Milords, the qualitatively also, Milords, it has to be assessed. And, Milords, they will have to give elaborate reasons, Milords, if they were to hold that I'm disentitled, Milords, to pursue medical course. If I may pass on this statement, Milords, for our Lordship's kind consideration.
You place this on affidavit.
Yes.
Day after tomorrow. Day after tomorrow. Then we'll take a what to do with which judgment you will.
Milords, Supreme Court, Milords, was dealing, Milords, with similar issue, Milords. At para 7, Milords, is the relevant portion. If I may read, Milords.
Here what relief is given? Finally, by the Supreme Court. It is an interim order, list on 310. Find out what is the outcome of this process.
My lords, it was sent back, my lords, for reassessment, my lords. For reassessment, in view of these observations, my lords made earlier. I'll place that on. I'll place that.
We are open for that or even, my lord, even now.
Day after tomorrow. You place this on record and with this,
Yes, ma'am.
with type copy of this nature of disability.
Not, as far as my difficulty is this, Lord, I cannot go into the expert opinion. I go by their.
No, you just type version.
Yes, that I will.
You are for AEA.
AA. Assessment is done by three doctors.
But only quantitative. Only quantitative assessment.
Quantitative assessment, they,
Quantitative is not done.
that's the reason I'm mentioning, my lord. Like at the other day, you lost.
See what to do.
Yes.
Just get the subsequent.
Yes, yes, my lords. I'll place the final order.
Day after.
Yes.
Deeply authorized.
Please.
Number 3, Bipin Negde.
May I please? It's on 18/7. Your lords are pleased to permit us to implead the fifth respondent and hand summons were taken. Lords, we have filed an affidavit. When went to serve on the fifth respondent, he has refused. We've taken the photographs of the person refusing, and because of that, my lords, he has not been served, but he is aware of the proceedings, my lords, before this honorable court. Kindly see the affidavit now filed, my lords. On 29/7. Page 3, your lords will notice the court's notice. He is in Andhra Pradesh, Anantapur.
What is this? This is something. I had gone to number 5, refused to receive summons.
Your lordships directed us to serve by hand summons. And my lords, we took the hand summons to the place of residence of the fifth respondent. As can be seen from the photograph, my lords, the court notice there was attempted to be served on her. She has refused in an affidavit to that effect has been. Sit down. It's just a brief factual background.
This Teja Khanna was joined.
Yes,
The seat, my
She has
lords.
refused.
yes.
She is not refused, my lords. According to us, she went to the college
No,
and they
please
did
let-
not admit her.
That
and
is
then-
not,
That
the
is our
refusal
stand.
of the hand summons is what the court is asking. Let me just give the factual background, my lords. Factual background. Let's, the petitioner, the fifth respondent was allotted a seat and she was required to get herself admitted by 11th, which was the last date under the allotment letter. Kindly see page 7 of the statement of objection filed by the KEA. Page 7 of the statement of objection, my lords. She, on the last day, apparently sought to withdraw her candidature and wanted the refund of the money. The complaint, those stated that they demanded huge sums of money and she was harassed. Effectively, she wanted to withdraw her candidature and wanted it to be, her fees to be returned by the KEA. But under the settled position in law, once the seat is allotted and payment is paid, fees is paid in the KEA, it's a deemed admission. So question of institution refusing doesn't arise. It's only a question of reporting to the institution by the candidate. Apparently, she had some difficulty in getting herself admitted, so she sought for refund of the amount, which effectively meant withdrawal. It is in that case alone she is entitled to refund of the fees paid by her. Let's page 7 annex to the statement of objection, annexure R2 would show that on 11th November, late night, she demanded return of her fees paid. In furtherance of this, my lords, apparently nothing happened before the KEA, and therefore, my lords, since she did not report by 11/11, the institution wrote a communication to the KEA, which my lord will find at page 34 on 15th November. Sorry, 13th November. Pointing out that out of 5 candidates who have been allotted, only 4 have reported. The Teja Krishna Sri has not, though has downloaded, has not reported. Therefore, send some replacement. Therefore, looking into the matter and allot another candidate as a replacement to fill the sole vacancy. That is at page 34, my lords, annexure J, which was on 13th November 2023. As nothing happened, my lords, the institution wrote one more letter at page 35, annexure J, again pointing out that the 15th is the last day, the seat will go wasted, please fill this up.
What was the last date?
15th, my lords.
11.
15/11. The institution also wrote to the Director of Medical Education as per page 37 on 15th, saying that the seat is going wasted, she has not reported.
So what happened to this?
There was no response to these communications by the college to the KEA.
Page 33.
Page 30, 34, 35,
Series.
36, 37. Repeatedly, my lords, they represented to the KEA, pointing out that there is a vacancy. It needs to be filled up before 15th and therefore fill it up. Since no steps were taken by the KEA, the institution proceeded to admit an eligible candidate who had qualified in the NEET and admission was granted. Apparently, this communication of 11/11/23 by respondent number 5 to the KEA was referred to the committee, saying that the monitoring committee is required to look into. What is important is, my lords, in this communication grievance which was made was refund of the amount and no request for grant of admission was made. If, my lords, she were to withdraw after 11th, then the amount would have been forfeited. Therefore, on 11th evening, she wrote a communication to the KEA to refund that amount, though a grievance is made that she was not given admission, harassment has taken place. The committee was sent, this communication by her was sent to the committee. The committee, my lords, without looking into any one of these documents, infers that I have in fact denied. Instead of ordering admission of the candidate, she it directs refund of the amount by the KEA, and the KEA has refunded that amount. Therefore, my lords, apparently she is not interested, and therefore she doesn't want to participate in these proceedings. The fact remains, my lords, insofar as petitioner is concerned, she was eligible for admission. Admission has taken place before the last date. It was communicated to the authorities of her admission. Therefore, my lords, she is being denied appearance in the examination which is scheduled from 9th. Lords, in similar matters, though not in medical, your lords have by interim order have directed the university to allow them to take the examination. The committee's order also, we have challenged it in a separate writ petition, which is item 4, wherein your lords are ready to direct notice. It has come for the first time. Therefore, ultimately, your lords, when judicially review the order of the committee and find that these documents which we have sent, intimating of the vacancy, is to be taken, my lords, there is nothing wrong in this admission. Though, my lords, the KEA has now filed its objection, pointing out to committee's order and therefore saying I am not entitled. But your lords could ultimately consider our pleadings are complete as to whether she is eligible to continue her studies or should he be denied appearance in the examination.
May I make my submissions? She's paid the fees, my lords, but.
That has been refunded, my
My
lords.
lords, page 8 of the statement of objections clearly state that on 12th itself, she writes to us that they are not admitting and demanding the entire 5 years fee. Page 8 months. Lords, she writes to us.
No, let's, KE has to explain why they ignored series of communications from 34 to 39. When I pointed out she is not reporting and therefore fill this, we didn't ask for filling up the petitioner. Fill anybody who is eligible. Only because they failed, Milords, we had to fill it up on the last day. Because, Milords, the committee goes into this and says we have denied her. But order is not to admit her. We offered, Milords, even before the committee that will admit her, even that day when the committee was hearing the matter. The committee did not want, because student was not interested in getting admitted. She was only interested in getting back her money. And that's also the reason on 11th itself, she wrote asking for refund of the money. Let's under the brochure of the KEA, if it is not withdrawn before 11, then it gets forfeited.
Your Lordship may kindly see page 6 of the statement of objections, which is the directions issued by the National Medical Commission. Lords, there cannot be any physical mode of admission to a medical seat.
Yes, I have prosecuted, I have to take examination scheduled from 9th. Subject to the outcome of their filing details objections. Let's A, the KE has not explained why from 11th to 15th, no steps were taken to fill up by any candidate. Second is the only issue which my learned friend is making by reference to annexure R1 is that there can't be admission outside the process of the KEA. Let's a division bench of this honorable court, my lords, has taken note of the fact that if pursuant to a consensual arrangement, which permits on the last day, if no seats are vacant, it is permissible for the institution to fill them up by eligible candidates. That was also the scheme by order of the Supreme Court in Darussalam, where they said you can't allow the seats to go wasted. It is on those circumstances on the last day, I made the admission, the college has made the admission. No, I'm only requesting, my lords, permit us, subject to your lords' further orders, my lords, on the continuation or otherwise of this candidate. There's no claimant for this seat. It will go wasted otherwise. Last week, under similar circumstances, your lordships have ordered permitting them to appear in the examination, though, lords, it is for the Ayurveda courses.
Dismiss.
Yes, my lords.
Refunded, my lords. Please, my lords, it will be, it has been refunded. My lords. So I'll get the instruction, get that.
Not for the NMC, my lord. There are, in this matter, there are two dimensions to it. First is, as we saw in my learned friend pointed out 7, 8 and 9 are emails there, which point out that the candidate is saying they are not allowing me to join because they are demanding extra fees. That is page 8 and 9 is full of those emails. Paragraph in page 15, if my lord sees, the committee also says that they were there at that particular day when the college denies that they were not there. GPS statement is also shown before that they were present in the college premises. Now, all that having been done, two things flow from that. If a candidate has been admitted into a particular seat, and if for whatever reason, let us assume they are right, the other person is right. That issue is yet to be decided. Whichever it may be, the overseeing committee has already decided in one way by pointing out a certain fact. But what would have happened, my lord, if this, let us assume one scenario, why these matters are important before this court is for this reason, which I have been urging all the time. I'll give, my lord, two more numbers of the same institution where similar situations are there to which they have to be connected. That is one submission, my lord. The other submission is this, my lord. Once the admission has been made, if on the next day the person does not come, will they still say, I will admit somebody else? The fee has been paid, the student has been admitted, and their stand is the person is not coming. Now, we are not going to see on the floor what has happened, but the overseeing committee has come to the conclusion that the GPS statement showed that the candidate had gone there. That's a finding of fact. So if in the connected matter that has been, they have challenged that, then both the issues have to be taken up together and that will have to be then decided. It is another matter, my lord, as we saw in the earlier cases. Now that one student has been admitted, again, fait accompli. Fait accompli has been the bane of our system, my lord. I have done it. Therefore what? I do not care. Let it be the judiciary, let it be anybody. Therefore, how do we deal with this is that aspect to be dealt with. That has been the only submission from the NMC's point of view. That how do we put an end to this fait accompli? We are not gunning for any candidate, as we have said earlier also. That is, we leave it entirely to the court. But where it is on record that a candidate has done this. Therefore, restitution. Restitution would mean next year one seat. College has to surrender to the system, to the government.
I appear for respondent number 3, Rajiv Gandhi University. Rajiv Gandhi University. I am for KEM. KEM. Respondent number 2.
Ninth.
My objections are on record, my lords. I request this honorable court to consider my objections and
There are two more matters are there to which this can be connected. Same institution. May I give the number? Same issues, last day issues. Those are different college. Those two are different colleges. This is a different college having 3 such cases now. 23817 of 24. 817 of 24. And the other is 23072 of 24. 72 of 24.
Yes. 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 Yes, I have been prosecuting these studies. All these are, my lords, under management quota. That's the next matter is the challenge to the order of the committee may be tagged with that. So after issuance of notice, no further interim order is required. That's item number 4, which is there before your lordships. It challenges the committee's order, saying that it has not looked into these communications. So your lordship may merely issue note. Yes. Hmm. Great.
Obliged.
Hmm.
So list number 1, so contempt matter, seal number 1, so Pradeep, yes, so far.
Here for the complainant, my lord. My lord, order is, my lord, annexure B. My lord, operative portion is at page 33. Please, my lord. My lord, the relevant portion, my lords will find at page 35. My lord, I was direct, my lord, the respondent number 1, who is the accused before your lordship in this matter, my lords, were directed to pay 5,000 per month. My lord, in fact, it's a continuous cause of action because till date they failed to pay. In fact, my lord, after passing of this order, I had also made an application for payment of arrears and, my lord, to enhance. My lord, that your lordship will find at, my lord, annexure C, page 49. In fact, along with this, my lord, I'd also produced statement of accounts at page 53. My lord, what happened is, my lord, suit for partition filed by, my lord, the widow, my lord, against, my lord, the family of the husband. My lord, without giving any share to her, my lord, they had, my lord, asked her to leave. My lord, during the pendency of the suit, my lord, the accused was paying maintenance at 4,000 rupees per month. My lord, after filing of RFA, my lord, there was a specific order by, my lord, the learned single judge. My lord, the relevant portion I just pointed out to your lordship at page 35. My lord, they continued to pay maintenance even after filing of RFA. Only thing is, my lord, in 2012, October, they stopped paying. My lord, when that was the case, page 49, my lord, annexure C, I made an application for arrears. My lord, date of the order is, my lord, 12/4/2010. My lord, they continue to pay me maintenance. My lord, what happened is this was an order, my lord, to pay maintenance every month. My lord, they continued to pay till October 2012. My lord, because they stopped paying after that, I filed another application before the learned single judge. My lord, that your lordship will find at page 49. My lord, for payment of arrears. My lord, despite filing this application, even today, till today, they, my lord, failed to comply with the order of the. Plus, my lord, I have made a specific pleading, my lord, in my application also. Please, my lord, it's a continuous cause of action because, my lord, they have to pay every month. My lord, maintenance have to be paid every month. That's the order of, my lord, the learned single judge. My lord, till today, they failed to pay, my lord, the maintenance. In fact, my lord, she's a widow having a daughter. My lord, in fact, as of today, my lord, the arrears come up to almost 12 lakhs. My lord, she's a widow having a daughter, my lord, not able to maintain, uneducated. And the order of learned single judge has not been complied with. Every month they have to pay. My lord, if it was, my lord, a time-bound specific direction, my lord, I would respectfully submit before your lordship, my lord, that there is delay. But, my lord, the order is, my lord, to direct them to pay every month. RF is pending, my lord. RF is pending hearing and they've stopped paying me maintenance completely, even though there is a direction by this honorable court. I have in fact moved separate applications there for payment of arrears and for deposit of, my lord, these maintenance amount which have already been ordered. That also, my lord, has not been done. Therefore, my lord, I was left with no remedy but to approach this honorable court under contempt. And, my lord, this is not a time-bound order, my lord. This they have to pay every month to me. And every month of non-payment, my lord, keeps getting added as arrears. Therefore, my lord, there is no delay. I'm sorry, my lord. My lord, appeal against, my lord, a judgment passed in a suit for partition filed by me, my lord, against my family of my deceased husband.
And my lord, I have produced, your lordship will find. Yes, my lord. I have produced, my lord, because my lord, out of the estate of the family, they were deriving rents for almost 2.5 lakhs. And my lord, I had a right in my husband's share, which they denied to me. And from those rents, my lord, the court had ordered to pay a minor amount of 5,000 per month in maintenance. In fact, my lord, if your lordship sees page 64 of the petition. Page 64, my lord, is an order dated 1/3/2014 in the RFA, my lord, where I had, my lord, made a submission regarding non-payment of maintenance and, my lord, arrears. In fact, my lord, the court had come down heavily saying, my lord, despite the interim order, my lord, he failed to pay the maintenance, and, my lord, page 65. My lord, the learned single judge directed them to pay arrears and to continue to pay earlier maintenance. My lord, your lordship sees page 53. I have produced the statement. My lord, till today, my lord, they have no other source of income, and the order of the learned single judge has not been complied with. My lord, I have been moving, my lord, that matter and application for, my lord, payment of arrears. My lord, even there, my lord, they have not been paying. Therefore, my lord, I am seeking indulgence by this honorable court. As of today, my lord, almost 12 lakhs of arrears, and the daughter is studying, minor daughter, my lord, no other source of income. And even till today, they have not complied with the order of the learned single judge. RFA is also pending, my lord. That's the reason. In fact, Lord, if your lordship permits, my lord, I'll serve the counsel of respondent, my lord. Please, my lord. My lord, huge amount as in, my lord, arrears have not been paid. This is the direction by my lord learned single judge. In fact, my lord, if your lordship permits, I will serve the, my lord, accused, who is the respondent in the RFA. My lord, I am, my lord, the accused is the father of my deceased husband. Please. I am claiming my husband's share, my lord. My father-in-law. I am claiming my husband's share in the property, my lord, and they are getting rents of almost 2.5, 3 lakhs per month. My lord, I had filed the suit for partition then only, and my lord, throughout the proceedings, there have been an order of maintenance which they had been paying, but suddenly they have stopped paying. And I have no other source of income. I'm uneducated. I'm
Paying till 2012.
Please, my lord.
Now thereafter also 12 years has passed.
My lord, thereafter, my lord, I had made an application for payment of arrears and deposit of, my lord, this amount. Then it single judge, my lord, noticing that, had, my lord, ordered for payment of arrears and to continue to pay, my lord, the maintenance. My lord, they refused to pay that. And they're getting huge sums of money. And my lord, I am, my lord, uneducated. I am widow. And my lord, I have a minor daughter. My lord, considering all of these aspects, my lord, the learned single judge had directed, my lord, payment of maintenance amount. Because I have a legitimate right in my husband's estate. And all these 7 brothers, my lord, they are refusing to give any share to me, thrown on me out of the family. But I have nowhere else to go. Therefore, my lord, I had made this application before the single judge. All I'm seeking is, my lord, whatever there is a direction, my lord, let that be complied with. That's my only relief that I've sought. Nothing else. Because RFA is still pending. My lord, as of today, my lord, the girl is, my lord, in the completed a schooling, and my lord, fees and all has to be paid.
Notice written alone. Fifth September.
Lord, I may be permitted to serve the council, my lord, representing respondent. Please.
Number 2, Shashwat Narayan Naik.
Notice
my lordship, you appear for
30th
Ah.
August.
complainant, employee is present before the court. And issue notice to accused 1, 2, 3, my lordship,
Notice.
notice.
Number 3, Mr. Ravi Kumar TK.
Notice written on 3 also. Same date.
Number 4,
There's a
submission in
portal number 12.
Notice.
to pass.
number 4,
You issued notice.
Yes, ma'am.
number 4.
For the petitioner, my lord.
Number 4,
Please, my lord, I may permitted to submit on behalf of my senior because I'm not on the record, my lord. Please, my lord, this PIL petition is filed against the illegal deputation, my lord. And for the implementation of annexure A and B, my lord, may kindly see that. Page number 42 to 45. Page number 42 to 45, annexure A and B, my lord, implementation of annexure A and B. Kindly see that. Translated copy of annexure A, page number 43.
So you want to enforce this circular?
Yes, please, my lord.
They'll do that. Who are you to come?
Please, my lord. My lord, the petitioners are the residents of the different talukas of Uttarakhand district, my lords. They are from the agrarian families, my lord. My lord, that particular circular is related to the, my lord, deputation of the village accountant as well as the revenue inspectors, my lord. They are doing the core work of the, my lord, at the grassroots levels, my lords. That is which is related to, my lord, death and birth certificate as well as the old age pension scheme and other works, my lord, which is deeply related to the, my lord, the poorer section of the societies, my lords. My lord, these farmers and the daily wage earners are, my lord, suffering a lot that, my lord, whenever they go to the office, my lord, it is the reply that, my lord, the officers are not available. They are deputed to somewhere places, my lord, and their work is getting delayed, my lord. And even for that, my lord, they're losing their daily wages. That is what, my lord. My lord, may kindly see that one of the work is related to the, my lord, that is the old age pension scheme, my lord, which is in consonance with the Article 41 of the Constitution of India, my lord. It was this program was implemented, my lord, and which is related to Article 21 also, my lord. If that program is not implemented effectively, my lord, then these people are suffering a lot about that, my lords.
So that, my lord, the annexure A and B is very essential to implement it, my lord. The Tahsildars, my lord, on their own whims and fancies, but without any authority of law, my lord, deputing the village accountant as well as the revenue inspectors, my lord. The deputation authorities only rest with, my lord, the deputy commissioners, my lord. Annexure A, B, and, my lord, even the annexure Q also kindly be see that, my lord, at page number 98 is, my lord, translated copy, my lord. Kindly see that, my lord. That is a direction even from the government side also, my lord, not to depute. Even that also, my lord, the Tahsildars.
Heard learned advocate Mr. So and so for the petitioners. Five petitioners who claim to be the residents of the Bhatkal Taluka of Uttara Kannada district, and further claim to be social workers doing social work along with their profession. I have moved this public interest petition inter alia, complaining that the respondent authorities have not been implementing government circular dated 29/10/2013. As per the state government circular figuring on record, the deputy commissioners and the higher authorities are instructed that the services of the village accountants and revenue inspectors should be utilized only in their respective departments and working jurisdictions, and that they cannot be engaged for clerical work or other work elsewhere. What is sought to be submitted paragraph by the petitioners is that by not following the said requirement, because of non-following of the said requirement, work in the offices suffer and get delayed, and the citizens' work gets delayed. paragraph, the foundation of the public interest petition is too weak to be entertained. The general plea that the circular is not implemented cannot be entertained. Full stop. If any individual case occurs where the infringement of entitlement is established because of breach of the circular, it could be a ground to seek redressal in accordance with law. Paragraph. In filing such paragraph, in filing the public interest petition, which is as such vague and seek general direction. The approach of the petitioners appears to be a meddling approach. They are the busybodies who have filed the present public interest petition. The petition is meritless and the same is dismissed.
Number 5. Nachikeet Joshi, appearing for the petitioners in this matter. This petition has been filed with respect to constitution of the CSP, my lord, Civil Service Board. In a similar matter, wherein WP number 5216 of 22, a direction was issued by, it was filed on the similar grounds, my lord, wherein it was on order dated 24/2022, an order was passed by this court directing the government for a status report to be filed with respect to this. The direction of the Honorable Supreme Court may please be seen, my lord. It is at Annexure C. Page number 67 of the petition, my lord. 67 of the petition. May I read, my lord? It's at para number 29, my lord.
Of Supreme Court judge.
Yes, my lord.
Page
Page number 67 of the petition.
67.
It's Annexure C. Para 29. We therefore direct the center, state governments, and the union territories to constitute such boards with high-ranking serving officers who are specialists in their respective fields within a period of 3 months, if not already constituted, till the parliament brings in a proper legislation in setting up the CSP. One important fact here in my lord, para number 33 may please be looked into, my lord. It is at page number 69, wherein the purpose of filing this PIL will be served by looking at that, my lord. The reason is we are of the view that civil servants cannot function on the basis of verbal or oral instructions, orders, suggestions, proposals, etc. And they must also be protected against wrongful and arbitrary pressure exerted by the administrative superiors, political executives, business, and other vested interests. Further, the civil servants shall also not have any vested interest. Resultantly, there must be some records to demonstrate how the civil servant has acted if the decision is not his, but if he is acting on the oral directions, instructions, he should record such directions in the file. If the civil servant is acting on oral directions or dictation of anybody, he will be taking a risk because he cannot later take up the stand. The decision was in fact not of his own. Coming back to the paragraph number 30 itself, my lord, on page number 67. We notice at present, the civil servants are not having stability of tenure particularly in the state governments, where transfers and postings are made frequently at the whims and fancies of the executive head for the political and other considerations and not in the public interest. The necessity of minimum tenure has been endorsed and implemented by the union government. In fact, we notice almost 13 states have accepted the necessity of a minimum tenure for civil servants. In furtherance of this, my lord, Annexure D may please be seen, wherein a coordinate bench of this honorable court has directed at page number, internal page number 51 and page number 123 of the petition, my lord, the last page. May I please read, my lord? My lord has got it.
In any other state, such boards are constituted.
I'll have to look into it, my lord, but in the judgment of TSR Subramaniam, it has stated that 13 states
Point
have
out in
followed.
which states it is constituted.
One more submission in this, my lord.
You make substance later.
My lord, the petitioner submits that Punjab was the latest wherein this CSB has been formed, my lord. Punjab.
Bring the details. Then we'll come. Bring the details of Punjab.
Yes. Date may be fixed, my lord. I'll
When do you-
produce the document.
20th August.
Yes, ma'am. Much obliged.
6 to 8 are disposed number 9. P. Fred Richardson.
My lord, the petitioners 1 to 4 are contractors under the National Highways Authority. Between Tumkur and Shivamogga, 2 stretches of roads, we were asked to repair, relay, and do this. The area of dispute is this. I have been cutting the road and using whatever existing material which I had earlier quarried, paid royalty, and used for making the roads to do repair work. And in additional requirement, I've got a quarry license. I'm getting it and paying royalty. Now the state government says that even for and all these road lands belong to the NHAI. I have produced a sample RTC also. Your lordship sees page number 224. Now the state government says that even for the materials for which I've already paid royalty earlier years ago, and now which I'm just cutting the road and reusing them, I have to pay royalty. All along, they rely upon a judgment of the apex court from Orissa, where the railways were using granite jelly. But there, in that case, the railways did not have a quarry license. And therefore, the Supreme Court said that even if you are the central government, all this is required. Here, there is no allegation about quarry license. What they are doing is, even for material belonging to me. Now, my lord, under the minor minerals concession rules, Karnataka has got a slight change. There is an exemption given under Rule 3 capital A 4. My lord, there it says leveling of any lands by a landowner within his own land is exempted from obtaining quarrying lease or license. My lord, we have annexed this at page 222. This is the area of dispute where continuously they have been issuing us notices and in fact seizing our machinery without mazer and leaving it at the local police station. Finally, under protest, we paid 70 lakhs of rupees saying that we are not liable to pay. NHAI has written to the state government saying that we are not liable to pay. The first notice issued by them is at page 75. I produced even the translated copy also. I am not quarrying any fresh material and using, I'm using the material which is available. Rule 3, capital A, 4. Well, the judgment of the Honorable Supreme Court is also annexed to this at page 231, where the facts as obtaining in Orissa are completely different.
You are there? You are there?
Yes,
What is it?
Lord, this is a notice issued by the Deputy Director of Mines and Geology for utilization of minerals while constructing the road. Admittedly, petitioners are the contractors. They have extracted minerals like boulders, muram, and this notice was issued seeking, Lord, what is the exact amount of the mineral used for construction of road? What is the length of the road? There are 5 such notices have been issued by the Deputy Director of Mines and Geology to the contractors. They are liable to pay royalty for the minerals used for the construction of the road. There is no license issued in their favor.
One of the roads on the land on which the roads are being belongs to NHAI. Under Rule 3A4, there's no need of quarrying or license. And these are rocks and boulders, jelly which was used earlier years ago when the road was first made. I'm reusing them. There's no, and already royalty has been paid on that. There's no question of paying a second time royalty on something which already royalty paid. If I require any fresh goods, I'm quarrying.
You are claiming exemption?
My lord? No, I'm not claiming exemption. I am saying that what I'm using is what is the stone available in my own land, on my own land. What if I require fresh boulders, I've got a quarrying license for which they have no, that's not their complaint. They're saying the stones which I had used earlier in the road, which I'm reusing now to level the road, you pay royalty again on that. This is that's the specific ground they're saying. And they're relying upon the judgment of the apex court on this.
With due respect, ma'am, that is not the case.
May I read the notices, my lord? I produced all 5 notices.
You file a reply, notice returnable.
My lord, in the meanwhile, could I be protected against stoppage over its National Highway 4206? Not make
No mandatory order.
one submission may make. My lord, it's a PPT for 15 years. I have to maintain. NHAI holds my money. If at all your lordship comes to the conclusion that I have to pay, they can always collect from NHAI. It's not that I'm saying NHAI has to pay me every time when I do work.
We'll keep it earlier.
Lord,
29th.
may
Yes,
I
ma'am.
make one submission? If they have grievance against him, Lord, Showcase notices issued again.
Prima facie it appear they only show cause.
Showcase
But there are
notice.
demands.
In some cases, there is a demand.
Demand,
demands,
Lord, if
yes.
they are aggrieved by the demand, Lord, they can approach the revisional authority and convince them. There are disputed facts. They are saying they are reusing the material already, Lord, used for construction of roads.
They're
If that
continuously
is the
stopping
case,
the
Lord,
work,
that is not the
seizing
case
my
at
machine.
all. Fifty-three is available.
You file notice return.
Shorter date.
Shorter date. 29th.
That's it, my lord. My lord, the problem is that every day, on the 10th of July, they seized my thing, took it to the police station and dumped my.
20th August.
Yes.
Apply.
Let them not seize my machinery. I'd lie in the police station, somebody, they'll be, there, my lord. Lord, at least it's with me. Nothing will happen. If it's go to the police station, they don't take a master, they leave it in the jurisdictional police station. My lord, these are all costly equipment, my lord, which I have also put in money for it.
Let the reply comments.
Number 10, Ravindra Gajanan Pillai.
So you are, after he is successful bidder, you are revising the amount?
Lord, he, no doubt he's a successful bidder, Lord. Within the stipulated time, he has not got executed the lease deed. Thereafter, after lapse of some time, Lord, he came and sought for execution of lease deed. At that time, during that time, Lord, during the period of auction, this was the amount, Lord, earlier.
So this bid price is based on the royalty rates.
Yes.
May I submit my lords? Initially, the rate of royalty was 60 rupees per metric ton. And I was a successful bidder for a sandbox reserved for special category scheduled caste and scheduled tribe, my lords. I had offered 5,900 times above or based on that rate of 60 rupees royalty, my lords. And that is apparent on Annexure B at page number 31. I am at first successful bidder, my lords. And that rate comes to 3,540. That has been mentioned in the letter of intent issued by the senior geologist, whereas the bid was finalized by the district task force committee comprising of the deputy commissioner as the chairman. This senior geologist issues a letter of intent wherein he says that I am liable to pay 3,540 per metric ton, for which I was willing, my lords. The one of the conditions that I should obtain quarry plan approved and obtain environment clearance certificate. Since this was in stream or alongside of the Tungabhadra river, which is stream 4 and 5 of the river, my lords, it has taken a lot of time for the environment committee to grant me the license, and ultimately they have issued me the environment clearance certificate on 15/7/2023, which I produced promptly. Accordingly, a quarry lease came to be executed, which I have produced at annexure E, my lords. It is at page number 39, my lords. In that, my lords, and certain words were interpolated without the authority of law, which was not noticed by me at the time of execution of the quarry lease deed, my lords. It is at page number 41, my lords. In the first paragraph itself, whereas the lessee has offered, shall I read, my lords? Page number 41.
There is stipulation to pay the additional.
All those things I have paid, my lords.
No, in this intimation letter dated 13/9/19.
Yes, my lords. It is the
Stipulation
first
that-
page itself at page number 32, and at English translation at page number 35, my lords. In the last bottom line, it is mentioned as rupees 3,540.
The deed is executed in the year 2024.
Yes, my lords. In between, the rate of royalty was,
Auction took place in 19.
yes, my lord.
E-auction process held on 6/9/19.
Yes, my lord.
Then on 12/9/19, the chairman approved the said auction and ordered to issue letter of intent. For each cent block, the bidder has to pay additional periodical payment, royalty, district mineral, as applicable to the department. Now, you file your reply, how do you assess? How do you justify this?
Lord, because there is change in royalty. In the year 2019, royalty was different. Now it has been increased in the year 2024.
You are varying the contract unilaterally.
Lord, that was an understanding.
Auction was concluded.
Lord, in that case, Lord, anyway, he has submitted representation at annexure F. That is his prayer also, to consider this representation. We'll consider this representation in a time bound manner.
Where is that?
Annexure F, page 16.
Page 15.
60,
60.
my lord.
60.
in a time-bound manner, if they are to consider, my lords, matter can be disposed, my lords.
Moreover, his prayer is to Lord consider also. Second part of the prayer.
By issuing a corriendum or a rectification or a.
Considered in accordance with it. It will be considered in accordance. This is relevant, Lord, in the contract itself, in the lease deed itself, the amount mentioned is, Lord, 4720. And he has executed.
So that is, I mean,
The registered lease deed. Your last may kindly peruse page number 41.
That is right, given.
Yes.
It is a lease deed,
yes, my lords.
lease and license.
That is the interpolation. It is without my notice, my lord.
Interpolation, it is a registered document.
You're true, my lord. I fully agree, but just only to take out, if any interpolations have been taken out, my lords, the same senior geologist has verified that. At page number 49, my lords, of the lease deed may kindly be seen, my lords.
Heard learned advocate Mr. Ravindra Kolle for the petitioner and learned government advocate Mr. S.S. Mahendra for the respondent state and its authorities upon service of the copy of the petition in advance. In this petition filed under Article 226 of the Constitution, from what the petitioner has prayed is to require respond number 4. That's the senior geologist and the competent authority, Department of Mines and Geology, to consider the representation of petitioner dated 14/6/2024. The prayer is also to require the said respondent to pass a corrigendum order confining the bid amount to ₹3,540 instead of the revised rate of ₹4,720. The facts paragraph in the background are that the petitioner participated in the e-auction dated 6/9/2019, which was conducted for the purpose of disposal of sand blocks reserved for scheduled caste at Tirthahalli Taluka, Dabanagadde village, which was sand block number 2, head measuring approximately 12 acres. Also, the petitioner had a FRED as successful bidder, having bid the price of ₹3,540 per metric ton. It is the case of the petitioner that the sale price reflected 5900%, 5,900% escalation. Why there was a gap of this intimation letter and the lease deed? Lease deed is of 2024.
For lord, intimation is
because-
2019.
EC was very lately issued, my lords. EC was produced on 15/7/2023. Unless and until EC is issued, my lords, query lease deed will not be executed.
The
my lord.
intimation letter was issued to paragraph to the petitioner on 13/9/19.
May I just produce the copy of the EC, my lords?
In which it is inter alia stated that on 12/9/19, the chairman of the deputy commissioner, district send committee, Shimoga, approved the auction and directed to issue the letter of intent to the successful bidder. It was contemplated that for each sand block, the bidder has to pay the additional periodic payment, royalty, district mineral trust fund, and other applicable charges to the department. It appears that pursuant to the finalization of the said auction as above, the lease deed came to be executed between the petitioner and the department on 14/3/24. The lease deed figures on, the copy of the lease deed figures on record. From a learned government advocate would invite in the attention of the court to the stipulation in the lease deed. Which provides, which mentions, which recites, RECITES, that the lessee has offered the highest bid of rupees 3,540 in the bid public auction held on 6/9/19. And that the amount is revised. Amount of rupees, and the amount of rupees 4,720 is the revised amount of royalty rate. On the other hand, learned advocate for the petitioner would contend that after the bid was successfully cleared by the petitioner and the amount of rupees 3,540 was offered and finalized, it was not permissible to the authorities to unilaterally hike the price from rupees 3,540 to 4,720. Lease deed is executed.
Yes,
It's a registered lease deed.
It is on 14/3/2024, it is
Would
executed.
invite attention of the court to the registered sale deed between sons, date sons, registered date comes. In the aforesaid conspectus of the facts obtained in the controversy, the only relief which could be granted to the petitioner is to permit the petitioner to make a representation to the competent authority respondent to be considered strictly in accordance with law. If such representation is made, the competent authority of the respondent shall consider the same in light of the.
We have already submitted the representation, my lords.
Considered the competent authority shall consider the same in light of the operative facts, preferably within a period of 2 months from today. Full stop. At this stage, learned advocate of petitioner submitted that the petitioner has already made representations.
Please, my lords.
Full stop. The authority, it is open for the petitioner to make a press representation if so desires. For miles, the authority shall consider the representations already made by the petitioner within the above stipulated time. Paragraph. It is clarified that the authority shall proceed to consider the representation in accordance with law and on merits. And in that regard, the court has not expressed any opinion on merits.
Please.
And is accordingly not entertained, subject to the above limited direction.
Number 11. Shivali.
This is deemed conversion matter under section 95(9).
Is covered, Lord.
Covered by
95.
judgment produced at annexure F, page number 37.
So they
Deemed
discovered that order to be passed. Where is that order?
Lord,
It is ordered at page number
Annexure
37.
F.
Page number 37.
Only caveat is not, if the representation is not already been considered,
If not decided.
if not decided.
So we'll pass the order.
Please.
Disclosed. What is your name?
Shivali, S.Y. Shivali.
11. Shivali. You mentioned. Our learned advocate, Mr. Malik Fadul.
Only correction that
Will-
in Lordship's order at page number 40.
We have seen annexure F.
Please.
It is there.
Annexure F. That order was passed in
Same,
connection
the
with.
same line, except we'll say that if not decided.
Please. And that order was passed in connection with the stone crusher work here. Here, this is the Karnataka minor rule condition.
Natural.
So number 12.
Please, my lords. In this matter, my lords, the order passed by the third respondent director is assailed, which is based on the belatedly issued revenue opinion by the deputy commissioner, which was passed without the authority of law and source of power contained under Rule 8(5), Sub-Rule 1 and 4, my lords. That is very explicit as per annexure X at page number 176, my lords. Wherein the director, pursuant to the order passed by this honorable court, produced at annexure C, my lords, dated 8th June 2023, directing the director to consider my saved application, my lords. It is at page number 39, my lords.
29.
39, 39. This is the copy of the order passed by this honorable court, my lords. In writ petition number 11-609 of 2023, it is dated 8th June 2023. At page number 39, I may kindly be permitted to read 4 sentences, my lord. Subsequently, there were certain amendments carried out to so and so, which came to effect between the years 2016 to 2023. The case of the petitioner would fall in exception to Rule 8(b)(2)(d) and E of the said rules of 1994. Accordingly, the writ petition is disposed with the direction to the respondent number 2 to decide the petitioner's representation dated so and so as expeditiously as possible, not later than 8 weeks therefrom. Acting upon this order, my lords, the third respondent director wrote a DO letter to the deputy commissioner on 1/7/2023 to give your opinion within
90 days, as required under Rule 8(5) Sub-Rule 1, which the Deputy Commissioner never responds. Later on, thereafter, again on 1/1/2024, the director writes another letter to the Deputy Commissioner. Pursuant to law, you are supposed to give the NOC within 90 days, which you have not done. And in view of latest amendment carried out in Rule 2023, that is Rule 8, Sub-Rule 6, my lords. He requests that on the same day you convene the task force committee meeting and take a decision. Otherwise, you'll have to face the contempt proceedings. The rule, Sub-Rule 8 of Rule 8, I may kindly be permitted to read my law. Sub-Rule 8 of Rule, Sub-Rule 6 of Rule 8, my laws. If the Deputy Commissioner or the Assistant Commissioner of the Revenue Department or the Deputy Conservator of Forest or the Assistant Commissioner of the Revenue or the Deputy Director or Senior Judge, as the case may be, fails to give no objection certificate or joint inspection report under Sub-Rule 5 within 90 days from the date of communication of the same, shall be placed before the District Task Force Mines Committee in its monthly meeting by the concerned Deputy Director or Senior Geologist. Next, provided that the officer who fails to issue no objection certificate or joint inspection report as specified in Sub-Rule 5 shall be summoned by the District Task Force Committee and obtain opinion from the concerned officer in the meeting and record in the proceedings of the meeting, and the same shall be disposed of accordingly. It's a clear mandate given, my lords. In crystal clear terms, the person or the officer who fails to give the either the no objection certificate or joint inspections report, there are two different things. He shall be summoned in the meeting of the District Task Force Committee. And to that extent, this third respondent director writes a letter at page number 177, my lords, and requests to convene a meeting today itself by the senior geologist.
Which rule you read? 8(5)?
8 Rule 6, Rule 8, Sub-Rule 6.
8(6).
Yes, ma'am. Again, shall I read, my lords?
So he wants this much relief on placement of the matter before the District Task Force Committee.
Yes, ma'am.
Because within 90 days from the date of the report, dated 26/9/12, the no objection is not issued.
Not received.
No, this is a case, Lord, wherein no objection certificate has been issued by the Deputy Commissioner.
After 90 days,
Deputy- may-
after 180 days, 195 days he passes, my lord, which is of no consequences.
No, no.
Without placing it in the meeting of the District Task
Opinion
Force
is
Committee.
with regard to land, Lord. It is a Gomal land. Whether he gives opinion within 90 days or after 90 days, the status of the land will not change. Lashma can kindly see, peruse Sub-Rule 5 of Rule 8. It is the Deputy Commissioner is the authority in respect of Gomal land. Lord, if they are aggrieved by the opinion expressed by the Deputy Commissioner, Lord, they have to challenge that opinion before the appropriate authority. Appeal is provided under Section 49 of Land Revenue Act. Now they are questioning the order passed by the Deputy Director of Mines and Director of Mines and Geology, based on the opinion rendered by the Deputy Commissioner. The base for this, that order, the opinion expressed by the deputy commissioner or order of the deputy commissioner is not called in question in the present writ petition. Therefore, the very writ petition is not maintainable.
May I submit, my lords? This is
So the deputy commissioner already objected.
Objected.
my submission, my lord. My application is of 2012. When Gomal land is applied for, there shall be a joint inspection by the jurisdiction assistant commissioner along with the senior geologist. That it provides in the provision, my lords. Rule 8.
If the
Fi-
authority already objected to.
No,
Yes.
it is, no, I think, with all respect, let me see, because I get disturbed. My only submission, my lords, in the year 2012, application was filed. Immediately, the assistant commissioner and the senior geologist proceeds to this spot and issues a joint inspection report stating that no doubt it is a Gomal land, it is full of rock bed fit for grant of a quarry lease.
Fit or not fit?
Fit for grant of quarry lease.
Fit.
Yes. Till 2016, no steps were taken. In 2018, when law came to be amended on 18/12/2017, the senior, the deputy director writes a letter to the deputy commissioner. You give me a no objection certificate or no opinion as provided under sub-rule 1 of Rule 8(5), my lords. Rule 8(5), sub-rule 1. That says, in case of specified minor minerals, the deputy commissioner of the district concerned and at page number 40 at annexure D, I was issued a joint inspection report by the assistant commissioner and the senior geologist. In view of that report, my lords, there is no occasion for anybody to issue a subsequent report in the year 2024. This report cannot be taken away. This has been issued pursuant to a provision provided under Rule 8(5) to 1 and 2, my lords. That reads like this. Provided that in case of all minor minerals in Gomal land, the assistant commissioner of revenue department and deputy director or senior geologist concerned, who shall furnish a joint inspection report through the deputy commissioner. So here the deputy commissioner, right from 2012, holds back. He puts in the cold storage. But in 2018, again, the director writes a letter, DO letter, to the deputy commissioner. That is also not responded. Again, in the year 2023, this honorable court passes an order with a direction. You consider the query lease application within 2 months. Thereafterwards, the director writes another DO letter to the deputy commissioner. With all respect, joint inspection report has already been there on record. Now it is only for you to submit that through your kind selves. That was only the requirement, not the, again, joint inspection report. So there is no occasion for anybody to file another joint inspection report as of in 2024. Only he has to forward the joint inspection report carried out in 2012. Thereby, forest NOC was already received, technical report was already received. It is almost in the process of grant, since there are 3 other query leases are operational there, my lords. Merely because contempt proceedings are initiated, this dilatory tactics is adopted, my lord. And I'm not for the timing pursuing the contempt proceedings, my lords. But in between, I came with great respect, my lords, just to bring to this honorable court how the order passed by this honorable court are respected by the functionaries of the government, my lords. And within 3 days, my lords, after 180 days, the deputy commissioner says that no, this is not a suitable land for quarrying, which is per se not in accordance with.
I will reply. To clarify.
Not even otherwise. Not, they are questioning this impugned order passed by the deputy director. The revision, if they are aggrieved by this order, revision is available under 53. 53. And if they are aggrieved by the order of the opinion of
Agreed by which order? Annexure L,
Annexure A,
Annexure A.
page number 27.
Annexure A.
Yeah.
It's no doubt it's an order passed by the director, my lords. But the issue is the deputy commissioner's actions are now challenged. That cannot be decided in a revision, my lords.
That is not under challenge in this.
That is the second thing. You better present your statement of objections. You will argue the case. I will also produce the decision of.
Deputy commissioner's opinion or order is not under challenge in this.
There is no provision, my lords. It is only the order passed by the
No, if they are
director.
aggrieved, so let me kindly-
Where is that opinion?
Opinion
It is at annexure B at page number 31, my lords. It is in Cambridge at page number 33 onwards. That is the English version, my lord.
So it is already refused.
Refused.
So then this consideration for no objection doesn't arise.
Because my only submission, my lords, this opinion is given after 195 days, which is impermissible under law. It is not at all in existence. If he has given such an opinion within 90 days from the date of communication by the director.
6 doesn't come into picture. Sub-rule 6 of rule 8 will not come into picture once this order is at an excess.
No, here in sub-rule 6, my lords, no objection was not used. It is the opinion. In sub-rule 6, so the proviso, they mention that it is the obtain opinion from the concerned.
There is no question of opinion.
Oh, no, it makes no objection is mentioned in sub-rule 5, my lords. Here they come as opinion, my lords. This is my humble submission, my lords. In the proviso, it says so. So that distinction probably legislature wanted to make.
So you want annexure B decision to be placed before the board? You want annexure B decision to be placed before the board?
Maybe, my lords. If it is placed before the task force committee, that is.
Committee.
Please, my lords.
May make a submission. 8.5 may kindly be seen. Rule 8.5. He is relying on the rule which came into existence from 17/3/2023, new rule. In the earlier rule, 8.5 is the requirement for grant of quarry lease. May take your lordships to sub-rule 5 of rule 8. Can I read? The competent authority shall, before granting or renewing a lease or license, consult: one, in case of specified mineral, the deputy commissioner of the district concerned and obtain no objection certificate. This is a specified mineral. DC has to grant no objection,
Not granted.
not granted.
That is,
And if they are aggrieved by the lot opinion granted by DC, Kailash may kindly peruse section 49 of Land Revenue Act.
That is not attracted for KMNC rules, my lords. It is almost in the nature of
It is
deviating.
in respect of a land. The opinion in respect of a government land, opinion was granted by the deputy commissioner.
But what about proviso? See, proviso to rule, sub-rule 5.
But if that be the opinion, my lords, why the assistant commissioner and the,
Provided that in case of all major minerals in Gomala land,
yes, my lords,
assistant commissioner or revenue department
Yes.
and deputy commissioner,
that has been done, my lords.
who shall furnish joint inspection report.
Yes, my lords.
And it has to be submitted through the deputy
Yes.
commissioner. Again, deputy commissioner will come into picture. Ultimate deciding authority is deputy commissioner.
It is not ultimate. Their report, joint inspection report should be submitted through the deputy commissioner. He cannot be kept in dark. Whatever joint inspection report carried out by the assistant commissioner and the senior geologist should be submitted through or routed through that office, my lords, to bring that to the notice of the deputy commissioner. That's only the requirement of law.
You better file your
Please, my lord. Please, my lords.
notice returnable on 20th August before the next date.
The notice may kindly be accepted by the government. Notice may kindly be
I
accepted by the.
accept notice.
Before the next date, reply shall be filed by the respondents. Learned government advocate, Mr. Mahendra accepts the notice.
Writ appeal matters, serial number 13. Mr. K.
I'm a-
Sridhar.
I'm appearing for the appellant, my lord. There is a delay of 10 days in filing the appeal. My affidavit has been filed.
Delay of
Delay,
10
my lord.
days, notice returnable on
My lord, I may permitted to serve the
8th of
council.
August.
I may permitted to serve the council who appeared before the land.
Chowdhury.
December 14. HR Krishnamurthy.
30 days delay is there, brother.
Delay,
Yes, sir.
delay is there.
30 days delay.
Notice returnable on.
I appear for the respondent.
Agreed by the impugned order passed by the single judge. Portal 2023, commencing at page number 10 to 15. madam.
Notes all that the learned single judge is ordered is only for repody, my lords, after giving notice to all interested person. It's an innocuous order.
In fact, after 49 years of delay,
Why you are aggrieved?
Only repody, that's all.
reporting is though 1971, the
Notice to everybody.
Everyone. I am also having 10 guntas. That's an admitted fact in this very survey number. Actual measurement says that there is overlapping of properties. Repody will solve the problem. There is no, absolutely no.
So you are for all the respondents?
I am for respondent number,
First.
first respondent, contesting respondent, my lord. For all others, state.
Lord, I appear for respondents 1 to 4.
I am for respondent number 5.
Yeah, one, only
Respondent number 1 to 4, state, my lords.
Sir, new respondent.
One. Writ appeal one.
Huh?
Writ appeal one.
Writ appeal 1. I'm sorry, my lords. In writ appeal, I am respondent number 1. For respondent number 2 to 5, it is state.
So we condone the delay. All are appealed.
Yes, ma'am.
IA number. So you are for number 2.
I am for number 1, my lords.
Respondent
Respondent number 1. Same.
No, no, I am for 2 to 4.
2 to 5. State is for 2 to 5.
To all. Heard learned counsels appearing for the respective parties. IA of 1 of 24. This application is filed seeking to condone the delay of 30 days in filing the appeal. Full stop. Having heard learned advocates for the parties and having considered the elements made in the supporting affidavit, which explains the passage of time, it could not decide that the delay is culpable. Full stop. Sufficient cause is made out to condone the delay of 30 days. It is condoned, application is allowed. Then write down order in writ appeal. Having condoned the delay as above, the writ appeal itself, writ appeal was taken up for consideration. Heard learned advocate Mr. Krishna Murthy for the appellant, learned additional government advocate Ms. Neelofar Akbar and learned advocate Mr.
Sharat Eskauda. Sharat Eskauda.
So and so for Neelofar Akbar for 2 to 5 and learned advocate so and so, number 1. Full stop. The challenge in this appeal is directed against order, judgment and order dated 4th December 2023, passed by learned single judge, disposing of the writ petition. Full stop. It was paid by the petitioner appellant. Was ordered, it was to set aside order dated 5/1/22, passed by respondent number 1, Joint Director of Land Records. Respondent number 1 dash Joint Director of Land Records, as well as order dated 15/12/1971, passed by the Assistant Director of Land Records. And the direction was prayed for against the authorities to conduct thorough and prepare sketch afresh in respect of land bearing survey number 39 of Sonnahalipura village, Sulibele Hobli, Hoskote Taluka. The case of the petitioner was that survey number 39 in question was a Gomal land and 10 guntas was granted to the petitioner. The petitioner was in possession, it was claimed, to the extent of 20 guntas in survey number 39 oblique P21, in addition to the aforesaid 10 guntas. It was stated that while carrying out the FODI of the said land with the petitioner, a new survey number 132 was assigned. The land measurement overlapped with the land belonging to respondent number 5. It was the case of the petitioner that he was not heard while carving out new survey number. And the total area thereof. In the circumstances, paragraph, the only order passed by learned single judge is that since impugned orders were passed without issuing notice to the petitioner who was directly affected, comma, they were quashed and the case came to be remitted to respondent 3, Assistant Director of Land Records, for redoing the Durast and Fodi in respect of land in question, to be done after issuing notice to all the concerned, including the petitioner. Paragraph. The directions passed by learned single judge of remitting the case and affording opportunity of hearing to the petitioner, des appellant, while doing re-durast along with other petitioner, along with the other parties concerned, while redoing the durast and Fodi could be said to be eminently just and proper, eminently just, legal and proper, no interference is called for. The appeal is meritless and the same is dismissed.
My lord, may I make one submission? My lord, at paragraph 12, time limit has been fixed for completion of, my lord, the Durast and Fodi. If my lord could extend the time, because we are
Stop.
7 months away.
The press exercise of undertaking durast and Fodi as directed by a single judge and confirmed by this court shall be completed within.
Lords, already 1 year time is granted, my lords.
1 year,
Again,
7 months have gone by in this
my lords, this is
litigation.
not the, and writ appeal now, there is no stay, nothing here.
Within 4 months from today.
My lords.
Order was on 4/12, my lord.
Within 4 months from the date of service of order of to the.
Obliged.
My lords, they are parties, my lords. They are the
My
state
lord,
has
it's
to.
not- I'm not saying anything. It's just that we want to do it within the time frame. And learned single judge has.
Normally
granted
from the
one
date
more
of
time.
receipt of the order. Yes.
Case number 15 to BJ Somayaji.
So within 5 months from today.
Well, without receipt of the copy.
Correct.
Because they are the parties.
Hey, they've been-
I pay for that.
Lord, serial number. I am for first respondent in this matter, my lord.
Me.
I have a submission to be made, my lord.
No,
The
no.
impugned order, my lord, which has been produced before your
I-
lordships.
He is a cavator. I have not made my submission.
One second.
The
one
same thing you have done with the single judge also. Let me make my
Let us
submission.
not stay in this.
Pardon?
My lord, I only make this submission. Wrong order has been produced. Subsequently, this order has been modified by the learned single judge. This has not been placed on record before your lordships. This I wanted to bring it to your lordship's notice. My lord, 3/1/2024 order was passed by the learned single judge. My lord, subsequently on 12/3/2024, my lord, it has been modified. This order is not placed before your lordships.
No, I filed the appeal, my lord. This is the order given to me.
No, this-
After filing of appeal,
Counsel
he moves it for being spoken to.
No.
Without, the only change he have made was the one writ petition is dismissed and the writ petition is allowed, nothing else. Let him show what is the, my lord, here what happened, writ petition is allowed, what it is not there. That for being spoken to, one writ petition is allowed and writ petition is dismissed, that is all. Apart from that, there is no change. Well,
Before-
that is why I'll make a submission, my lord. My writ petition filed is not considered by the learned single judge. My lord, may point out. The,
If
there are
ord- if
two.
order is subsequently modified, you
No,
place
no,
that.
it's not, no, I'm not aware of that. My lord, this writ appeal was filed on February 2024. It is not modified. Subsequently, he says, for being spoken to, it is posted, and what is modified according to him?
So you are challenging this order dated 3rd of January 24.
Yes, ma'am.
So the council says that this order you are challenging is subsequently modified.
Let him point out what it is.
I will point up if you.
No, yeah,
Please point.
let him point out what it is. No,
I pass on that, my lord.
By making a submission, it is modified.
that
That is
particular
for
order,
being
my lord.
spoken to. No, see, after the, my lord, judgment is rendered, No, the judge cannot pass any order unless application is filed. It is posted for being spoken to, he says modified. What is the modification? Let him show. Except saying that, well, that is what the judge showed, because in my absence it was done. One retribution dismissed and another retribution allowed, because it is not mentioned here.
Lord, matter.
That is why my submission was, I filed the writ petition, that writ petition was not at all considered by the single judge. I said,
Order passed by the learned single judge, insofar as my writ petition is concerned, has attained finality. Both the matters were clubbed and orders were passed. What is now challenged before your lordships is the one what they had filed. Lord, they ought to have challenged both the orders before your lordships.
both.
Lord, my order as my writ petition orders are final.
He doesn't want to challenge.
My lord, in all this confusion, the land belongs to the government, my lord. That has
This
not
is
been
what,
brought
this
to
is,
the-
my lord,
This is
not
why-
even a single
that is-
document
may-
is
may I
placed
point out,
before
my
the
lord?
court to show that it belongs to
My
the
writ
government.
petition, my writ petition is not considered, but.
I don't
my
know
lord,
why
I-
Gram Panchayat, my
The
lord,
Adhyaksha, my lord, the moment, my lord, I submit. Adhyaksha of Taluk Panchayat has no jurisdiction. He filed an appeal before the appellate authority. He has remanded the matter. Then he approaches the Adhyaksha of Taluk Panchayat under 237. He has no jurisdiction. That is what has been held by this honorable court for the last 25 years.
Now, this writ appeal arises out of which petition?
The same order,
Which petition?
both the petitions.
Both the-
No.
Yes. No,
Then my papers are not produced before your lordships then.
4439 and 1979. Then the prayer is also mentioned. What is 1999? It was not decided, not considered, whether the order passed by the Adhyaksha of Taluk Panchayat, whether he has jurisdiction or not considered. No, these type of cases are being disposed of for the last 25 years within a few minutes. The moment I say, this order passed by the Adhyaksha of Taluk Panchayat, is no jurisdiction, the order passed the order. In this case, although I questioned it, subsequently says he wanted to implement that order. On this matter, they may point out the para 2. My prayer petition number. I question the order by the Adhyaksha of Taluk Panchayat has without jurisdiction. This one consistently held order of Taluk Panchayat without jurisdiction. Without considering this, my lord, the order, he filed a writ petition for implementation of the order. Implement of this order.
No.
Without considering, my lord, whether that order is valid or not, it cannot be gone into.
If
On
both
on
the
the
order-
government land, direction is issued to issue a building license.
My lord, please take paragraph 18 and 19 of the order of the learned single judge, my lord. There's a mistake that has been committed.
Then was the facts stated are contrary to record. I
It
don't
has
want to
not
say
called
much
called
because
his orders
I want
in
to maintain the
challenge.
decorum of the court.
Question.
I'm-
Lord, what is happening? We don't know.
It's all right.
My Lord, this is very unfortunate. Lord, a simple prayer, my Lord, seeking for restoration of my khatha and to issue a building license was sought by me by filing a writ petition. My Lord, this writ petition has been allowed now. Based on a decree which was passed by the civil court, my Lord, and an undertaking given and an admission made before the civil court saying that, yes, this property belongs to you. My Lord, there is a specific undertaking being given. That is where I said, my papers are not placed before this court.
No, may I submit,
If
my lord?
really, my Lord,
The
he
civil
is
court has
agreed of
held-
that order, he should be agreed of that order.
The civil court has held, my lord, this is a government land. His suit was dismissed. Then he files an appeal. In the appeal, on the, my lord, alleged notice issued by the Assistant Commissioner for removing encroachment, the civil court holds that even the trespasser is entitled to protection. then it is open for the government to evict him in due process of law.
My lord, it's not a
Ground-
small extent, it's a huge extent, 100 by
100 by 120,
120 feet.
you want to knock it off the government property.
Has encroached upon it.
Sorry. That is not the
I
situation. I don't know why.
We will rectify.
No, it is
whatever
not that, my lord.
But this-
Kindly see,
Please take paragraph 18
Lord.
and 19 of the order of the learned single judge, my lord. We made a mistake.
this entire land,
So that is what I, Mr. Counsel, this appeal is referable to which petition?
Both the petition.
So then how can be one appeal?
No, I paid, the number they give one, I paid court fee, 200. No, it is always like that. Here numbering they do only one. No, there is a procedure in the High Court. Then they ask us to pay the court fee of 2. I paid court fee of 2.
So both the petitions are filed by you?
my lord, one petition was filed by me. The one which is referred as 44,000, my lord, 399 was filed by me. Now that is allowed, that is clubbed with 19,799 of 2017. My lord, this is the one which is filed by the other side.
My lord,
My lord, now
By them.
by them. My lord, both the matters were clubbed together and a positive direction was given to the appellant before your lordships now to restore my kata and to issue building license in respect of this particular property. For which, my lord, I have been fighting out since 1989.
without
From
deciding-
1989,
without-
kata was there in my name.
This order is passed in their petition.
In my, both are clubbed, my lord. Kindly see the cost title here
Direction
at
is-
page 11.
Direction is given to them.
To them.
So what happened to their petition?
Their petition, my lord, is also dismissed. That is what I said, it is modified.
But
That is what I've been telling my learned friend.
but
He is not
considered.
listening.
My lord,
It stands modified.
My writ petition is not considered. My writ petition, I
Wants to
have
mislead
questioned,
this court.
I
don't
have
know.
questioned, the order passed by the.
And a
Adhyaksh.
contempt
He has no
petition is
jurisdiction.
pending consideration before your lordships. My lord, contempt petition
Without
is,
considering my writ petition, direction, what I question, I have questioned the order passed by the Adhyaksh of Talpanchi without jurisdiction. Without considering that, he files the writ petition after I filed the writ petition.
Then
He
you-
should,
Then you confine this appeal to one of the petition of your choice.
no, I know, I have paid 2 court fee, my lord.
We don't have the papers, Mr. Counsel, of the other petition. There can't be one petition in respect of 2 orders, even if you have paid court fees 3 times.
No, it is not that, let it be confirmed by the office. They give only one number for writ appeal. They give only one number for writ appeal.
You must know which the appeal is against which in respect of which petition.
Both,
How can it be?
both.
My lord,
Both,
the
my lord.
prayer is that.
That is the procedure under by the High Court. They give only one number. Even though several petitions are there, they will give only one number. But we have to pay court fee of both, 200. That is the procedure. That may be inquired into my office. My lord. That is the procedure being followed. They will not give 2 numbers. In any writ appeal, they are given 2 numbers, I agree. In no writ appeal, they will give more than 1 number. This is the procedure. No, it can't be bifurcated. When an order is passed in both, it can't be bifurcated.
My lord, now I'm in a fix, my lord, because the respondent is seeking for issuance of a khata without title deed. And admittedly, the land belongs to the government.
This
Now, my
writ-
lord, if the
admission to
contempt.
that effect.
This writ appeal
I don't
Huh?
understand.
is directed
don't
against
understand anything because you want khata.
common judgment and order dated 3rd January 2024, passed by learned single judge in 2 writ petitions. one of which was number 44399 of 17, whereas the other was writ petition 19799 of 27. Paragraph. In course of the consideration of the appeal, when learned advocate for the appellant was queried as to he was queried as to which, queried about the, queried as to, in respect of which, in respect of which petition the present appeal pertains to, he was not able to answer. He stated that single appeal is filed as per the procedure. Against both the-
There is a
against the-
mail, all the parties, all the writ petitioners
Against the
participate.
orders passed, against the judgment and order in both the petitions. Full stop. Such a course is not permissible. Full stop. It will be open for the counsel for the appellant to.
May I submit, my lord, this is the procedure being followed in the High Court. They will not, my lord. That is why I made all the parties in both the writ petitions.
It was stated by the council that such is a procedure followed by this High Court. Also, registry should submit a report whether this is a correct course of action and whether there is such practice in this High Court. Report shall be submitted by the registry before on the next date, put up on 9th of August. Please. Or set 9th of August.
Now he has filed a contempt petition also. He has filed a contempt petition on the government.
Lord, may I make a submission, my lord? In serial number, list number 1, serial number 45, I appear 45, my lord. Serious matter. In 45.7, I have filed a memo for withdrawal. It may be, case may be dismissed as withdrawn, my lord.
45.
45.7.
Like. Learned advocate, Mr. So and so for the, it is writ appeal
Please, my lord, I mean, I have filed the,
for the appellant. Invites attention of the court to the memo of withdrawal dated so and so filed. Whereas the memo reads and reads is under. In view of the permission is granted to withdraw the appeal. Mr. Withdraw.
but serial number 51, my lords. Kindly permit me to withdraw, my lords. Serial number 51.
51. Like 51. Same order.
My lord, serial number 48, serial number 48 will be taking the matter today
We'll take.
at 3:30.
यहाँ तक पहुँचे, reach to. Let us see, we'll take. Forty तक, 40. Appeal है, ठीक है, ठीक है. Read appeal. ले लेंगे, at around 4. If it doesn't reach. How many?
Just one. For withdrawal, serial number 61, Mr. H.C. Shivram.
Appearing for the petitioner, my lord. Case may be disposed or withdrawn, my lord. Main petition has been disposed of.
Memo dated 31/1/24 is on record, filed by learned advocate for the complainant. Stating that the petitioner is inclined to, is not interested in prosecuting the contempt petition and wants to withdraw the same. Following is stated in the memo, then bracketed portion. In view of above, the contempt petition is dismissed as withdrawn.
Serial number 62, Mr. Krishnamurthy N.
I'm for complaint in this matter. Kindly permitted to withdraw this. Kindly permitted to withdraw this petition, madam.
True. Same order, whenever.
Serial number 63, to be mentioned matter, Rajendra Kumar Shingai.
I am for the petitioner in this case, your lord.
Appearing for respondent.
for the
number 2,
respondent.
my lords.
Lords, what has happened in this case is, my lords. Lords, I filed a writ petition 10186 for, I retired on 28/2/2015 because my retirement benefits were not given to me. I filed writ petition 10186 of 2018, my lords, seeking for direction for my retirement benefits. Then, my lords, while notice was served upon the appellant university, then, my lord, they issue me charge memo. Then I filed, my lords, writ petition 5350 of 2018. Both were clubbed and heard together and both were allowed, my lords. Lords, in appeal memo, my lords, what appellant has done is, my lords, in both the appeal memos, writ petition 53050 writ memo has been inserted, my lords, but writ petition 10186 of 2018 has not been inserted, my lords.
Whatever it is, but we have already taken a view
Yes,
by dismissing one of the writ petition, 460, writ appeal, 460.
Nine.
469.
9.
So same page.
Milords, in final order, Milords, para 2 may have to be changed, Milords, because in the now 469 writ appeal, paragraph number 2, Milords, it says in now disposed of writ appeal, Milords have considered all the grounds in both the appeals. But Milords, in paragraph number 2, if Milords may see, Milords have said that in writ petition number 10186 of 2018, charge memo was issued. It was Milords writ petition 53050 of 2018.
Writ petition number?
53050 of 2018.
Really will make it.
And Milords, in 10186, I had sought for release of retirement benefits, Milords. That is not considered in this. That has not come in this order, Milords, final Milords.
What
Time.
release? We'll
By
see. Will be appropriately add the.
Milords, may I? Because they have not mentioned filed writ memo of 10186, if I may file it, Milords, during the course. Because it is not there on the records, Milords. Obliged, Milords. Obliged, Milords, deeply.
Number 64 to SB Mukanappa.
Complaint in this case. Complainant.
Complied with.
Complainant is not.
Lords,
complied, and which
private
cost, my lord.
institution, my lords, they had to pay salaries.
To-
Respondent number 4 is the private institution. They had to pay salary to the complainant. So far as government is concerned, we have complied, my lords. I filed the affidavit.
So reinstated.
Reinstated.
So when you will pay the back wages? Reinstate directed to draw salary of the petitioner, make over the same thing. So that part is remains salary, payment of salary.
Lords, it is a private institution. The direction is against the respondent number 4, not the government.
Number who is appear for? It's not coming. It was stated that the part of the direction regarding payment of salary is to be discharged by respondent 4. Since last 2 occasions, nobody has been present on behalf of respondent 4. When the contempt petition was taken up. In that view, there shall be a press notice to the respondent 4 returnable on 28th of August, failing which the court will be constrained to issue a warrant for present against respondent 4. If on the next date, nobody remains present on behalf of the court will be constrained. Yes.
Number 65. Shant Kumar KC.
Complaint.
Complied.
Complaint, madam. Partially is complaint, madam. What happened, madam?
What part?
I have purchased the property in 4 acres land in 98, madam. The respondent number 2 is measuring the and Durasti. Only 3 acres, 20 duntas. 20 duntas is left, madam.
What is to be complied with? Annexure L?
Lords, 4D and Durasti.
4D and Durasti, madam.
And that is produced in the compliance affidavit minutes.
Is already done, my lord, but 20 duntas is not demarcating and.
The
Liberty
20
to-
guttas is the Kharab land. As per the RTC's minutes.
That may be dropped, my lord.
Lordship may kindly take page 5 of the compliance affidavit. The name of the complainant is found at column number 9, my lords. The total extent is 4 acres, out of which 20 is Kharab. It's shown as Kharab. So we have done it for 3 acres, 20 guntas.
Direction in the order dated 7th March 23, as per the learned single judge, was that the respondent 3 was to undertake the process of Durasti and Fodi. As per order dated 24/9/21. After notifying the parties concerned. It was provided that the action in terms of an XRL to the petition was to be, would be completed in stipulated time. Full stop. When the breach of the above directions were complained of in the present contempt petition, or in response to the notice issued by the court, respondent has appeared to file compliance affidavit dated 10th July 24, in which it is interiorly stated thus in paragraph 3 of the affidavit. Paragraph 3, bracketed in compliance with the order. Efforts. Full stop. The copies of the revenue record has been produced in substantiation of the averments. Full stop. The revenue record in form of GNA, and RTC form number 16, into bracket page 5, bracket over, indicates that the name of the petitioner is mutated in respect of the land, barring the Karaba land. There has been a substantial compliance. The contempt proceedings are not required to be continued anymore. They are accordingly disposed of and not surviving. If any grievance paragraph persists, the remedy of the petitioner may be open in accordance with law to institute separate independent proceedings, in respect of which this court does not express any opinion on merits. Yes, next.
Number 66.
List of cases.
My lord, may be permitted to file the synopsis on behalf of the appellant. ಕಾಪಿ ಕೊಡ್ರಿ ಸಾರಿ ಅವ್ರಿಗೂ ಕೊಡಿ ಸರ್ಕಾರದವ್ರು
Maharaja of Mysore.
That's true.
Yes.
Well, initially, just I shall explain what exactly I have made in the synopsis. My lord, the first item number A to D in the first page and the second page, both of us, we are not disputing the facts. We are not disputing the facts, but as a matter of principle, we should inform accurately what exactly has been transpired. For that purpose, I may not take much of your lordship's time. Each survey number, what is the survey number, what is the extent when I have purchased this property, and what are the land revenue entries, etc. Well, for the purpose of submissions at this juncture, I may only take it as record, my lords, because I wanted to proceed on the legal questions which I am placing it for my Lord's kind consideration. I wanted to proceed on that. The questions which I have framed is available on page number 11 of the synopsis. No, I could have put it on the first because 11 of the last paragraph. Therefore,
Last page
where is this?
of the synopsis.
Of the synopsis only.
Therefore, it is.
Therefore, it is submitted that the following questions arise. In the absence of final notification under section 6(1) of the Mysore Land Acquisition Act 1894, whether the court can hold land acquisition proceedings is completed. That's the first question I have raised it. Second question, the agreement between the government and the company under section 42 of the chapter 7 is not available. Does it not lead to the conclusion the acquisition is not complete? I mean, these are, according to me, my lords, these are the mandatory things so far as the section 6 is concerned, so far as the section 42 for the company under chapter 7 is concerned. Third one is regarding the rules of natural justice. The order sheet maintained by the deputy commissioner is interpolated page number so and so. Therefore, the action of the respondent authorities is in violation of a natural justice as such. Under the provision to section 135 of the Karnataka Land Revenue Act and an original suit number so and so are pending before the learned senior civil judge Bangalore Rural at Bangalore, whether the revision petition under section 136(2) could be invoked by the deputy commissioner. These are the 4 questions I have framed it, and for that, for each one, now I am proceeding with this land. How I have further made is, well, I have taken up the subject wise. One is regarding the land acquisition. Other one is regarding the Karnataka Village Office Abolition Act. The third one is regarding the Karnataka Land Revenue Act. Then the rules of natural justice and the order passed by the learned single judge. Order passed by the learned single judge. May page number 167. Is certain facilities and the concessions for the flotation of the manufacturing of the so and so company. It's only facility. What the important lines I can draw now, instead of reading everything, 3.1 paragraph. I shall read. The government will give free of cost unoccupied wasteland measuring about 70 acres near the Soladevanahalli pumping station. The quarters attached to the Soladevanahalli pumping station, except those required so and so. I am not gonna, what happened is 70 acres of the government land was decided to be allotted to the company as such. Next one, 3.2. Private lands measuring about 112 acres in the Soladevanahalli village contiguous to the above plot will be acquired by the government. The cost of the acquisition being charged to the company, the fine for the conversion of the agricultural land for non-agricultural purpose will be waived. So this is the second. we are concerned with this 112 acres approximately. Ultimately, it was found out to be about 118 acres, my lords. Now, then next would be the annexure L. I can pray my lords to kindly peruse page number 171. It is a typed copy. (169) the Xerox copy. 171 is a typed copy. Well, here only the acquisition of the properties recommended above is sanctioned. The assistant commissioner in charge of the Bangalore subdivision being appointed to perform the functions of the deputy commissioner under the Land Acquisition Act. The declarations so and so. Only he has been authorized. Then comes the preliminary notification under section 4.1. That is available on page number 172. The typed portion is available on page number 174.
Yes.
Highness Maharaja Mysore, that under mentioned lands situated at Soldevanahalli, Chikkbanavara village, so and so, need for the public purpose, namely with the MSPP, notice to that effect is hereby given to all whom it may concern in accordance with the provisions of section 4.1 of the Land Acquisition Act as amended by the Land Acquisition Amendment Act 1 of 1927. The government hereby authorizes the Assistant Commissioner in charge of the Bangalore subdivision to exercise the powers under section 4.2 of the Act under subsection 4 of 17 of the Land Acquisition Act as amended by Act number 1 of 1927. The government directed that in view of the urgency, so and so. So, by exercising the powers under 4.1, the government has decided to acquire this land. Government also decides that section 17.4 has to be invoked. Under section 17.4 of the Act, the inquiry is being dispensed with. I am not questioning that portion at all. Now, our lands are also situated. Then comes, on the same day, another notification was issued. Here exactly the conflict or the confusion started because of this notification. The typed copy is available on page number 180. One eight zero. Under section 4 of the Land Acquisition Act, as amended by the Land Acquisition Amendment Act 1927, the government of His Highness Maharaja of Mysore declares that the lands mentioned in the Soldevanahalli and Chikkbanavara, that is, we are concerned with the Chikkbanavara villages, be the same as little more or less needed for a public purpose for the Mysore MSPP under section 4 and 7 of the same Act. The Assistant Commissioner, Bangalore Subdivision is appointed to perform the functions of a Deputy Commissioner under the Act. Further, directed to take orders for acquisition of the said lands under subsection 1 of section 17 of the Act. So, my respectful submissions to my Lord here is, this notification only authorizes the Assistant Commissioner further, my lords. The government further directs that the possession of the said land may be taken on expiry of 15 days from the date of publication of a notice mentioned in section 9.1 of the Act. A plan of the lands is kept in the office of the Assistant Commissioner, so and so. Here, my lords, absolutely urgency has been invoked, but this is not an acquisition as such of the land. 17.4 and 17.1 were allowed to be invoked. After this, now the question, since the acquisition is for the benefit of the company, therefore, my lords, Part 7 of the Acquisition Act, 1894 of the Mysore Acquisition Act 1894 is applicable. I have produced the same act, my lord, though there are similarly say, but there are some wordings are changed. I have produced the original act of the 1894 of the 1927. It is available on page number 807, volume 4. The relevant portion would be chapter 7, which is available on page number 817. It commences on 807, but relevant portion on 817, volume 4.
Where is it?
May.
Eight one seven.
817, the relevant portion, part 7, section 39, I intended to bring to my lord's notice. And acquisition after the ಪುಸ್ತಕ ತೆಗೆದಿಟ್ಕೊಂತಾರೆ. May I read 39, section 39? The provisions of, this is important from my point of view, the provisions of section 6 to 37, both inclusive, shall not be put in force in order to acquire the land for any company unless with the previous consent of the government of Mysore, nor unless the company shall have executed the agreement herein after mentioned. I am underlining these words, unless the company executes an agreement with the government of Mysore as such. Now, I can straight away skip certain portions and I can draw the attention to section 42 there. Every such agreement shall, as soon as may be, after its execution, be published in the official gazette, and shall thereupon, so far as the regards the terms on which the public shall be entitled to use the work, have the same effect as it had formed the part of this act as such. Therefore, the questions which I'm posing myself would be, number 1, 6 to 37 will not be applicable unless company shall have executed an agreement, and that agreement should be published in view of section 42 of the act. Now, my lords, my question, I am posing one question to myself. If for any reason The final notification has been issued and placed before this honorable court. I am out of court. I am out of court. The very purpose of my argument or my submission is to the effect that final notification has not been issued under section 6. So therefore, I may kindly be permitted to read section 6 for a while and for a while, my lords, on page number 810. Subject to the provisions of part 7 of this act, subject, so whatever I have read it. When the government is satisfied after considering the report that may not be applicable, that any particular land is needed for a public purpose or for a company, a declaration shall be made to that effect under the signature of the secretary to such government or some officer duly authorized to certify its order, provided that no such declaration shall be made unless the compensation to be awarded for such property is to be paid by the company or wholly or partly out of the soul. Subsection 3 is important. Another point. The said declaration, next page, my lord, 811. The said declaration shall be conclusive evidence that the land is needed for the public purpose. Therefore, my lords, I will stop for a while here. I'll put one question. As I have made a submissions, as I have made a submissions to the effect that unless the final notification under section 6 is produced, according to me, the acquisition proceedings are not being completed at all. No agreement, no. But in this context, I am just drawing the one page from the land acquisition book of Ramachandra, page number 465. I have taken an extract of it. I am requesting court officer to kindly. Four, 6, 5, my lords, the top. In cases of urgency, my lord, in the page number 465 of that first page, maybe first page in that, in cases of urgency, which necessitates taking possession under section 17, the following conditions have to be fulfilled. The declaration under section 6 shall be published preceded by the notification under section 4, which relates to the acquisitions to define the lands, measurement and the land marking of the so and so. The general notice required under section 9(1) should be published. That's also mentioned in the notification also, but this is. So lapse of 15 days is compulsory. Because, my lords, this is the general principle. In case of company, agreement is necessary as per section 43. Therefore, my first submissions, the first point which I have raised, according to me, is in the absence of it, it is so. In order to substantiate that particular fact, a notification has not been issued. I am praying, my lords, even my learned friends are disputing it, but even with the dispute or without the dispute, I am making it very clear, with the dispute or without the dispute. Page number 825 may kindly be just see. other day just I read, the government order number dated so and so 22nd February 1937, dated 15th June 1938, number so and so, 24th June 1938 for the Mysore Stoneware Pipes and Potteries Limited, the government order directed the land acquisition proceedings failed. Reasons, the in-time procedure not following, but the Deputy Commissioner, Assistant Commissioner, and the company's private land owners' payments records not available. Final declaration was not issued by the government. And so the land acquisition is rejected, which was approved by the Chief Secretary. My lords, I'm posing one question to myself because my learned friend is disputing this particular fact. Number one, in the absence of this, whatever I have produced the endorsement, in the absence of this, the only answer to shut my mouth other than to send the petitioner out of this honorable court would be, as I made submissions, the agreement and the final notification, which even as on today, they were unable to produce it. Next, my lords, on the same thing, page number 826. Based upon the order passed by the Chief Secretary, the Deputy Commissioner passes an order that is also 12/10/1941, my lords. These two proceedings are of 1941. As per your office letter number dated so and so, on the above subject, on the orders of the Chief Secretary to the government, after cancelling the acquisitions of the land to the extent of 118 acres, 24 guntas in Chikbanavara and the Soldevanalli villages, and ordered the landowners of the said lands to bring the khata, kandaya, and also at the same time issued the order to the amaldar of the Bangalore Taluk to bring the khata, kandaya of the above lands compulsorily ordered over. It's a follow-up or the follow-up actions pursuant to the dropping up of the proceedings as such. Therefore, any right in favor of the MSPP arises only out of the acquisition proceedings. Merely because by producing two documents, they cannot claim, according to me, that the acquisition is completed. My lord may kindly see here, 1938. Even as on today, what is the plight of our farmers is the one thing. If I can speak about the 1938, where the farmers are standing, my lords. Even to enter the office of a Tehsildar, even now it's a difficult. In 1938, it could have been the remotest possibilities is there. But however, the government has decided to drop it. Under such circumstances, my respectful submissions to my lord is that now in this background, after having made this land acquisition proceeding, in this background, I pray my lords to kindly peruse the order passed by this honorable court against one of the, not the petitioners, one of the landowners, which is available on R15, page number 619. Order passed by my petition. Mark ಮಾಡಿದ್ದು ಗೊತ್ತಿಲ್ಲ. ನಾ mark ಮಾಡಿದ್ದು ಗೊತ್ತಿಲ್ಲ. This matter was disposed by this honorable court when a prayer was made by one of the petitioners to the extent of 2 acres, 19 guntas, on the ground that there is a long delay is there. At the stage of preliminary hearing itself, the matter was dismissed. Only based on, in 1938, a notification has been issued. my submission is this. In the absence of the same, the 6-1 notification, etc., it has not been verified. Therefore, it cannot be treated as a precedent when the necessary statutory provisions were not being considered by the honorable judge while he was sitting as a single judge of this honorable court. Once later, my lord has elevated. So far as the judgments are concerned, I'll touch a little later, my lords. Only are proceeding on the points so that immediately I can complete it. Next point I'm pointing out is regarding the Village Office Abolition Act. My lords, Village Office Abolition Act was initiated by writ petition number 5271 of 1995, available on page number 536. This order, a passing remark was made operative portion, just I shall read that. It's available on page number 543. In the result, for the reasons herein above stated, petition is allowed. The order of the re-grant of the land relating to survey number 79 and 80. I am not connected with those two survey numbers at all. Hereby cast. However, the authority under the act is, sir, I'm reading page number 543, sir. However, it is made clear that the authority under the act is at liberty to consider the application afresh on merits, if necessary, only after notifying all the persons concerned and after holding the inquiry. Here, my lords, the present respondent number 4 was not a party to the proceedings. Though the order has been passed in the year 1972, in the year 1995, writ petition was filed, and in the year 2001, since the petitioner was not made a party, it was remanded. The one important factor so far as this writ petition is concerned, I can pray my lords to kindly peruse the cause title here. The only for the simple reason, need not be, the Tehsildar is not a competent authority under the Koi Vivo Act, number 1. And he was not a party to the proceedings. He was not a party to the proceedings. Therefore, my lords, the proceedings have been initiated. Now, this is important. Proceedings have been initiated by the respondent number 4 before the Tehsildar, who is not a competent authority under the KVO Act. Under section 3, it is only the deputy commissioner who is competent authority. Powers have been delegated to the assistant commissioner. And this honorable court, in the judgment which I am quoting it once again, that is 2022, sorry, not 22, 2012. So this honorable court I am submitting has pointed out that the Tehsildar is not the competent authority under section 3 of the Act. Therefore, the two submissions so far as the KVO Act is concerned, number 1, land is totally different, owners are totally different, and the matter was remanded to the competent authority. The order could have been passed by the competent authority. It has gone before the Tehsildar. since I'm not a party, I need not challenge it, but it is only a fact that has been brought to the notice of this honorable court. Now comes Land Reforms Act. My lords, here, before I could just point out, some confusion or the mistaken notion has been happened because the name of the person who has challenged the writ petition or who has filed the form number 7 is Srimati Rajamma, wife of Chikkanna Reddy. I shall point out from the orders, my lords, just making it. Rajamma, wife of Chikkanna Reddy. However, it was confirmed by this honorable court, while confirming the form number 7 was rejected, while confirming the order passed by the land tribunal, this honorable court, learned single judge, has specifically said, I am not going to decide who is the owner and who is in possession. Only I am going to decide, I have decided here is so and so is not the tenant. I shall point out. After saying so, the learned single judge, how he proceeds with respect is, the same Rajamma has filed a present writ petition. It is totally inaccurate. I have purchased this property from Rajamma, wife of Krishna Reddy. I can demonstrate it with the documents, which are originally available before the learned judge. But that was a mistake which has been crept into the order that has made the learned judge to come to such a conclusion.
Well, it is a party in that proceeding.
No, I am a party. I am pointing out.
In this petition itself, page 598.
I'm party to it. I never said I'm not a party here. And I pointed out the last paragraph, we are not going to decide. May I pray, my lords? Page number 555. This is the order passed by the land tribunal rejecting the application filed by it is in Kannada and the English is also produced, my lords. What I intended to point out is only the cause title, nothing beyond that as such is concerned. But it is available on page number 575, my lords. The English translation is available on page number 575. T.C. Chikkanna Reddy, petty claimant, deceased by his LRs, Srimati Rajamma, wife of late T.C. Chikkanna Reddy. Now, that form number 7 came to be rejected. The matter was challenged before the Honorable High Court on page number 596. The person, page number 596. The person who has filed the writ petition is Srimati Rajamma, wife of Chikkanna Reddy. I am not the Rajamma, wife of Chikkanna Reddy. My lord may kindly turn to the next page number 598. The name, serial number 10, my lord, the respond number 10. Rajamma, wife of Krishna Reddy. I have purchased this property from Rajamma, wife of Krishna Reddy. Regarding this position, I pray my lords to kindly come to the last operative portion, page number 609. 609. I have insofar as the respondents who were impleaded as a parties are concerned, I have got impleaded there, concerned, since the writ petition is being dismissed, the basis of their claim to the occupancy, other portions of the land in the custody of the first respondent company is outside the scope of this writ petition. So this writ petition wherein they wanted to say that I am a party, my predecessor is a party, the Honorable Court itself has said it is outside the jurisdiction of this order. And this order was challenged in the writ appeal number 424, which is on the next page, page number 610. And it came to be rejected. So, my respectful submissions to my lord would be this Rajama, I can point out when I'm reading the page number 50 of the learned single judge's order, when I come to that particular point. Then comes the Karnataka Land Revenue Act is concerned. Land Revenue Act is concerned. Before I am the purchaser of this property. My lords, when I have purchased, etc., I have stated in the first paragraphs also. And for the purpose of convenience, on page number 10, formally, my lord may kindly peruse the notes, page number 10. Columns I have prepared it so that it can. My lord. This first one, survey number 80/3 from Sorojamma and others. Owner is, I have purchased this property. This is sale deed is dated last column 3/4/2007. I have purchased this. My lords, RRT date is important here. That is the fourth column 25/1/07. My lord may kindly just make note of this 20. I mean, these 2-3 dates I'm pointing out. Why I'm pointing out these particular dates is learned single judge, while passing the order against me, observes that I have purchased the property when the RRT proceedings were pending or RRT proceedings, after purchase, the RRT proceedings have been initiated. It is inaccurate. For that purpose, my lords, I'm pointing out for all the 4 survey numbers. Kindly see 25/1/07 is the RRT proceedings, page number, etc., given in the first page itself. Then, my lords, the sale deed is on 3/4/07. Likewise, for the second survey number, it is on 23/8/2006. It is on 11/1/2007. After the RRT proceedings, the Tahsildar passes an order in favor of my original vendor. I have purchased it. Then, my lords, 24/1/07 from Rajamma, wife of Krishna Reddy. That's what one of the one. And it is 23/3/07. 23/12/06, 10/1/07. My lords, my lord, I will pose one question to myself. I will pose one question to myself and I will answer it in this way, my lord. Being a purchaser, it is my duty to see that I should get a better title. And in the record of rights, my lord may kindly note that the 2 names were available. Number 1, the original owners. Number 2, MSPP. 2 names were available. I have asked my vendors, how is this MSPP name is available? Please, unless MSPP is deleted, I will not. Then, my lords, RRT proceedings have taken place. In RRT proceedings, the council from that side, from our side, have participated. Then the Tahsildar has come to the conclusion, number one, to the effect that the company has failed to produce the final notification and they are failed to produce so and so. Under such circumstances, the names of the MSPP was deleted. Another question I'm posing to myself, how did the name of MSPP has entered? I'm posing one question. How did the name of MSPP was entered? There is no mutation proceedings under section 127 to 136 of the Land Revenue Act as such. No mutation proceedings. That was also another reason. My lords, in the absence of mutation proceedings, as held by this Honorable Supreme Court and also by this court, I'm pointing out the judgment 2012, unless mutation entry, the entry is preceded by the mutation proceedings, it has no presumption under section 133 of the Act. Accordingly, the names have been deleted. So, let us assume, my lords, if everything goes against me, I'm assuming myself, what could have been happened? Two names were there. And in the year 2010, the company has filed 4 suits against me because of the 4 sale deeds. Those numbers, I have mentioned it, 1143 to 1140, 46. 1140 to 1146 of 2010. I have produced all the plaints also before this Honorable Court. Under 1143 to 1146, plaints are there. My lords, kindly see page number 8, that particular point, how I have I have mentioned the dates. Page number 8 of my notes. These revision petitions have been filed in the year 2012, 1/10/2012, and original suits have been filed on 8/12/2010. The original suit is pending and they are challenging my title and also for the cancellation of a sale deed. It's plaints also, it is available on page number 184 to 202, etc. Therefore, my respectful submissions to my lord would be that under section 135 proviso of Karnataka Land Revenue Act, I need not, it must have been brought to the notice of the court many times also. All the entries are subjected to the results, and once the original suit has been initiated, they have made a statement in the original suit also, I am producing the IL, RR, etc., this and that, they have not yet, but the matter is pending there as such. And in view of section 135, this is regarding Karnataka Land Revenue Act proceedings are concerned. Now, my lords, I am straight away, without disturbing much of the court's time, I am requesting my lords to kindly peruse page number 302. My lord has earlier day saw it, but as a matter of concluding portions, I am coming to that point. Page number 302, volume 2. The purpose for which it's a Kannada language, I'm producing it, and it is a blank. I have filed in the, my lords, when the original suit they have filed against me in the year 2010 itself, and in the year 2012, they have filed a revision petition. At least they should have impleaded me. No. Then, my lords, I got impleaded myself. filed an application for vacating stay. At that stage, the matter was heard. Madhyantara Adeshakkagi, for the interim order, the matter was heard and it was decided it is a blank, but ultimately it was found out to be the final order. To that extent, the violation of the natural justice has taken place. That is more fatal under section, so under Article 226 and 227 of the Constitution. Notes. Page number 9. I can pray my lords to page number 9, and also the order passed by the Honorable Learned Single Judge, which is available on page number 50.
We'll continue up to 4.
Very well, madam. I shall conclude. I shall conclude. Exactly at 4, I'm concluding it.
Then tomorrow.
I may not, because I'm so much grateful. I'm so much grateful to the court. Just within, I wanted to, because I should be obliged to the court, my lords.
You continue as many as you can, but today up to 4.
My lords, shall I? If my lord is taking up tomorrow, my lords, I can.
We are every day sitting. So tomorrow again we'll take up at 2:30.
Whatever my lord orders, I'll be following that order. My lords, it is not that I'm following the orders and I'm bound by the orders for that matter. I'm bound by the orders. Whatever my lord observes, I'm bound by it.
Only so that other matters do not suffer. Other matters do not suffer today up to 4.
Okay, fair. Now, my lords, I'm praying my lords to kindly come to the learned single judge's order, which is available on page number 47, but the actual cause, etc., it commences on page number 50. Page number 51. Learned single judge observes that on 5th line, 24/6/1938, final notification. While directing the Assistant Commissioner. Therefore, page number 51, 5th line, by looking to the annexure M and N,
Yes.
I mean, the same dates have been mentioned, 24/6/38, preliminary notification dated 24/6/38, and the final notification dated 24/6/1938, which according to me would be inaccurate, and it was misreading of the 2 notifications. That's all I have read to my lord. It's a misreading of the 2 notifications. Then, my lords, in the same, claims were made by the legal heirs of the erstwhile landowners seeking revenue entries, and it did not go through. It is inaccurate because that was pertaining to the KVO Act as such is concerned. Annexure R8 is pertaining to the Karnataka Village Office Abolition Act as such is concerned. Then, my lords, the next. Para number 3, my learned single judge proceeds on the KVO Act, and learned single judge proceeds that it has been heard by the competent authority. I have already made a submissions to the effect that they have filed an application before the Tahsildar. Tahsildar reopens it, opens it, and R11, page number 545. Only cause that I will show it, my lord. I'm not much of. 545, volume 3. Volume 3, volume 3. Only cause title may kindly be seen, 545. And I'll close at this juncture because my time is. It is in Kannada and the English language is available on page number 549. This is pursuant to the order passed by this honorable court. Order passed by this honorable court under the Karnataka Village Office Abolitions Act in the year 1995, writ petition 5778. Who could have been the petitioners, my lords? Who could have been asked? Because the matter is remanded. The original applicant should have been the applicants. But kindly see the Mysore stoneware pipe. They have been shown. And I have made a submissions to the effect that the company has filed an application. He took up the matter. Under the Village Office Abolition Act, according to me and according to section 3, etc., whatever I made submissions, that it is assistant commissioner, matter was remanded to the assistant commissioner, and it should have been proceeded on the assistant commissioner. It has not been done so. Therefore, the observations made by the learned judge to the effect that it has been on page number 53, consequent to the remand, the competent authority held an inquiry, which is inaccurate.
Mr. Holla.
Subject is
Please move on.
Number 48.
What is the urgency?
Advocate on record is a bit anxious. Issue is that it's a very small point.
What is the urgency? There is no.
particular. So,
then we'll
some
not take.
activities, the land has been acquired, some activities going on, that
I
is
think
only.
if there is urgency to take out of then we'll take over. Otherwise, let it come tomorrow or day after.
But may I then, because the point is literally very, very short. 5 objections under the Land Acquisition Act have not been considered. That's mandatory. And it's a fatal flaw. That's the only point. May I request tomorrow at 2:30 if possible?
Day after.
That much indulgence.
Day after we'll take.
Day after 2:30? Grateful.
Number 18. Chaitanya Hegde.
But there's a delay of 249 days. Now, 232 days is the period
Delay.
when review of it.
Review notice.
Not
Any-
so far as R1 to 3 is concerned, government.
All are appear.
R4 is only the private part.
Then you have to serve him. Notice it on 21st August.
Number 19. Mr. Srikanth.
Lordship, this is as against the order of the learned single judge.
It is with respect to senior citizens, Your Lordship. The order that came about was to confirm the order of the Honorable Supreme Court, wherein section 23, Your Lordship, if a gift deed is made, then if there is no specific clause with respect to having to take care of the elders, then automatically 23 would not be applicable, was what the learned single judge had opined. But Your Lordship, in this case, it's a little different. The father had already given by way of a gift deed to the mother, that is his wife, and she passes away. Once she passes away, he assumes that he again has the right and then gives a gift deed to one of the sons, who in turn creates a third party right by selling it off. The critical issue for the Assistant Commissioner to have actually gone into is, once the lady dies, who is the donee, then automatically the property then would have to be divided equally by all of them, in view of the fact that there is no will or nothing that she has left behind. That was overlooked by the learned single judge, and the learned single judge also, Your Lordships, has erred in certain observations, wherein he states that we have accepted that 15 lakhs was deposited with us. Your Lordship, the property is entirely that of the father. The 15 lakhs that came to him was through LIC, which he took. The amounts that went into his account was actually interest component on the LIC. This is entirely his hard-earned income, Your Lordship, and which now is given away to a third party, though no right arose at all by way of that gift deed. Your Lordship, in the writ petition filed by that third party who is the purchaser, Your Lordship, that purchaser is also.
You're appearing? I am for the caveat respondent number 1 thoughts.
Only one.
Yes, my lords.
Rest notice. Notice returnable on.
Might I only request, even if there's no interim order, that a fourth party interest then comes in, therefore status quo could be maintained, because we are told now the person who has purchased is now trying to again alienate the property. Status quo of maintained, Your
I will
Lordship.
not dispose.
That could be recorded, Your
I will
Lordship.
not dispose.
Status quo could be.
Third learned advocate so-and-so
I will not
petition
dispose.
Notice returnable on 3rd September, say 6th September. Learned advocate so-and-so appears for number 1. That's notice. First of learned additional government advocate Nilofer appears for number 2 and 3 and accepts notice on behalf of said respondents. Also, by of aid interim relief, it is directed that status quo shall be maintained by
Please.
both the sides.
I will not create any charge, ma'am,
Please.
In respect of.
That's
the-
obliged.
but it should not affect to change Kata.
No,
It was already.
nothing. Status quo automatically means we can.
Both, by
Obliged.
both the sides.
Please, obliged.
This number 20. St. Joseph.
Please, my lords. Lords, I have filed an IA for dispensation with producing the impugned order. Impugned order, I have filed an IA for dispensation. I got the certified copy. I have placed it by way of a memo. Lordship may kindly have a look at it.
So order of learned single is not there here.
Plus, by way of a memo, I have filed it yesterday.
No, then you insert it. We'll read and then 5th of September. Next.
I may be
Learned
permitted to
advocate
place
is
the.
permitted to insert the copy of the impugned order of legal judge, which is not part of the record, full stop, put up on 5th of September.
Number 21.
I may be permitted to file a memo.
Petitioner in the second.
With permission of the court, my lord.
21.
Ash may kindly recollect on last occasion.
I may be permitted to file a memo, my lord. One memo.
petitioner's advocate is replaced now?
No, my lord, I am filing a memo because they have filed one affidavit which contains lot of incorrect information. To bring the correct position before the court, I am be permitted to file one memo.
You are for petitioner.
Petitioner, my lord.
What you are filing?
So with permission of the court, may I say something?
Please give me copy.
Yes, the same.
So review petition is by you.
Yes.
Now. Fresh, yes. Today we'll complete it.
Yes.
Please. Give the
Lord, with
facts.
permission of the court, my lord, instead of the 21.2 petition, my lord, on behalf of the petitioner, that is a company, I am filing wakalat, my lord, with your lordship permits me, because there was an allegation against this council, and they had filed an affidavit also before this court. Now they filed. Instead of going all those things, my lord, I may be permitted to come on the record in place of present council.
It is your.
We have written letter and we have sent mail also, wherein we have informed that if they don't want to continue with us, and they may come and collect NOC.
You want to come on behalf of whom?
On behalf of the petitioner company in 21.2.
So file whatever you want time, we'll give time.
No,
You know,
No, unless I file wakalat, my lord, I am seeking permission of the court to file wakalat.
that is for the registry to decide whether to accept or not. It's not our job to permit or not to.
No, affidavit is also filed, my lord, kindly
If
go to
office takes
affidavit.
objections for one or two reasons, one or another reason, we are not concerned. It is for you and office.
No, my lord, what I am saying is since there is no objection from the present council, company filed an affidavit. On that affidavit, my lord, now they have given an wakalat to represent.
File it. Who prevents you? We are not preventing.
Please, my lord.
Anybody can file.
We have written the petitioner to come and collect NOC. They have not come, we are ready to give NOC, but they have not come and collected. From our side, there is nothing. We leave the matter to the decision of the court.
Whatever you want time, learned advocate, Mr. So-and-so appears in 6 time.
Lord, his name may be replaced with my name, my lord, in the call.
We are not here to replace anybody. It is the registry will do.
Yes. No, unless there is a permission of the court, my lord, registry may not do it. That is what I think.
the
Unless
entire-
there is a direction by the court saying that to,
It's in the business of the registry, not our business.
please, my lord.
September. 17 September.
Number 22.
Here for the petitioner and the matter, your lordships.
Appear as amicus, my lord.
No, this is a matter relating, my lord, to mining. There was an interim order granted by your lordships, my lord, that no mining should be taking place, my lord, where there is blasting involved. In my case, my lord, I'm not using any blasting. I'm excavating rock with non-blasting methodology. That's what the lease itself says. Because your lordships had granted an order, my lord, in a matter to which I was not a party, I, my lord, have filed an application for impediment and for clarification of that interim order. Because in my companion case, my lord, your lordships had directed that till the report comes, I cannot do mining. Against that, my lord, when the client had gone to the Supreme Court, the lordships, my lord, had permitted us to file an application in this case. Because your lordship's other order in my case was based on this order. So we sought leave, my lord, and leave is granted. And I have filed this application, my lord, only for this clarification. I'm not a party there, therefore impediment may be necessary. And my clarification only is that in cases where the party doesn't use any blasting at all. In my case, the mining lease says with no blasting.
and we are for crushing, we have asked even for crushing as such. It's quarrying and allied activities. So in view of that, we had sought clarification, Your Lordships, and government advocate was directed to they were supposed to conduct trial blasts 6 months ago and
Not
to file
conducting.
reports. Still today, the report has not been filed, Your Lord.
The trial blasting was contemplated. However, Lord, state level dam safety committee in the proceedings dated not 12th July 2024, they have decided to conduct a scientific study, my lord. I'm placing that on record.
There's already a scientific study I produced in my writ petition, Your Lordships. The Institute of Rock Mechanics has already filed a detailed report. I produced a copy, Your Lordships.
Who is for the petitioner? You are
I
for
appeal for the
petitioner.
petitioner, Your
Lord,
Lordships.
in the main matter, my lord, my learned friend appears for the petitioner in 19835. My difficulty, my lord, is there is 19835. In that, the interim order granted prevented any mining activity as a blanket kind of an order. My case, my lord, how it arose was, I have a mining lease where I mine rock for monuments, but the mining lease itself says I should not use any blasting. Because of the interim order granted by your lordships, my lord, in this case, they said you don't do any activity. So I moved an application, my lord, for permission to come on record and for your lordships to kindly clarify that the earlier orders, your lordships on the earlier occasion had seen, my lord, how that matter arose. There was a report, my lord, that this blasting is causing vibrations, etc. In my case, I'm not using any blasting.
Draw your lordship's kind attention.
Which is the relevant part.
Relevant is page number 25.
To copy to all.
Copy not given, Your Lordships.
May I also request for a copy?
Sorry. May I take your lordships to page number 25. 25, serial 23.
Yes.
KRS dam issues.
Yes.
As per the direction of Chairman SCDS, that is State Committee for Dam Safety, the Chief Engineer Irrigation South, Mysore narrated in detail about the present KRS dam issue in view of the writ petition number 19835, that is the present writ petition, 2023, filed in the Honorable High Court as below. In the wake of the loud noise heard on 25/9/2018 near Krishnaraj Sagar Dam, Karnataka State Natural Disaster Monitoring Center furnished a report on 25/9/2018 based on the signature recorded by the seismic monitoring station functioning in the premises of KRS Dam. In the report, it was recommended to avoid any mining activities affecting the safety of the dam within 15 to 20 kilometers from the dam. DC Mandya issued an order on 27/11/2018 prohibiting mining activities using explosives until the report on the safety of the dam is received from the Dam Safety Review Panel or until further orders from the government. In this regard, Director KERS suggested Chief Engineer and IS Mysore to contact National Institute of Rock Mechanics and Center Water Power Research Station, Pune. In their technical report dated 11/1/2019, suggested a trial blast to be conducted to measure vibration in the ground and additional studies. On 27/1/2019, when the CWPRS Pune team reached KRS for study, various farmers organizations held a go back movement against CWPRS, asking them to completely ban mining in the area KRS dam and not to conduct trial blasting. Hence, the trial blasting could not be conducted. CWPRS Pune requested to provide 2D, 3D stress analysis, FEM, and report on tomography of the dam body. In the meantime, as per the report dated 15/9/2020 by the Dam Safety Review Panel, it has been stated that all mining activities in the radius about 25 kilometers around the dam site be banned until expert opinion is obtained from CWPRS or NIRM After proper on-ground test, however, final CSIR, CIMFR, Dhanabad, which is the pioneer in mining operations, was approached. On 25/7/2022, the CSIR CIMFR team of scientists arrived at the site and checked at 4-5 quarry sites. Due to rainy weather, trial blast could not be conducted. The Honorable High Court of Karnataka, in relation to writ petition number so-and-so in respect of Sri C.G. Kumar so-and-so, the Commerce and Industries Bangalore issued an interim order 8/1/2024. The gist is as follows. All the mining license leases comprising any area, whether in private land, government land, or otherwise, that lies within the radius of 20 kilometers from the periphery of KRS Dam are hereby kept under suspended animation, and as a consequence, no mining or allied activity shall be carried on or continued by any person or agency till after a decision is taken by the statutory committee constituted under the provisions of Dam Safety Act 2021 on the basis of the report of study and research. As per the instruction of the government MD CNNL, that is Kaveri Neeravari Nigam Limited, in coordination with DC Mandya and concerned department, took preparatory measures for trial blasting from 1/7/2024 to 3/7/2024 for conducting trial blasts. Local leaders of Jilla Rait Sangha, Federation of People Organization Mandya, and various farmer organizations protested against the conducting trial blasting on 29/6/2024. In this regard, it was learned from the Prajavani newspaper report dated 4th July 2024 that the farmers organization intended to hold a massive protest against trial blasting on July 5th, 2024. The district minister held a meeting again on 6/7/2024 with the stakeholders from farmers organization and discussed about the issue of conducting experimental blast near KRS Dam. Senior officer from WRD district administration and experts from DRIP were also present in the meeting. After detailed deliberation, Honorable District Minister concluded that the issue be discussed in the next meeting, so and so. Putting forth the above facts, the Chief Engineer IAS Mysore requested the committee to give directions regarding further course of action. The chairman requested the member to express their opinion, suggestion on this issue, as the farmer and local people are agitating against conducting of experimental trial blasts. Opinion of the members is as follows. A. Professor so-and-so IISC and member opined that the possible damage that could be caused to the reservoir can be estimated through mathematical stimulation and validating using of the parameters of the explosion conducting in the vicinity of KR Sagar Dam beyond prohibited distance of 20 kilometers or in an area having similar topography and morphology or the parameters available from legally existing mining near the KR Sagar Dam, but beyond the prohibited distance of 20 kilometers. Professor so-and-so of ISC and member concurred with the above view. Professor Nanjun Rao, ISC member who participated in the meeting via online, also agreed with the above opinion. Dr. So-and-so scientist, Dhanabad, attending the meeting online, said that CSIR, CIMFR, Dhanabad, which is currently involved in the above said process, experimental trial blasting, have information data on the strata of area around KRS Dam, which can be utilized for validation of mathematical modeling. He also agreed to carry out mathematical modeling through proper validation. Chairman, after considering all the above opinion and discussion, directed the Chief Engineer, Irrigation South Mysore, to conduct CSIR, CIMFR for submitting a detailed analysis through mathematical modeling and proper validation. Now, Mlad, it is decided by the committee to conduct, instead of trial blasting, to conduct mathematical modeling and proper validation. The analysis report submitted by CIMFR, the Anamad may be vetted by subcommittee group comprising of experts from IASC Bangalore and our reputed institution organization for onward submission to SCDS for taking decision on the matter. Chairman directed the Chief Engineer, Irrigation South, Mysore, to take all necessary action for early submission of the abbreviation. Now, due to the agitation by the farmers, we could not conduct trial blasting. In alternatively, the experts have suggested mathematical modeling and proper validation is an alternative method of checking the vibration and impact of the blasting.
In the next page, my lord, where my learned friend read, there is a portion relating to my client, my lord, who is before your lordships, page 29. They don't do whatever they are supposed to do. They say farmer agitation. That means there is no police force, nothing in the state. Then, my lord, I give a representation. They refer to it and say matter is pending in court, so we can't do anything. At page 29.
Page 29.
29 in this report, which my learned friend read, at the point where he stopped, after that, representations to dam safety. Member Secretary explained the following representations. Item 1 is the present applicant. Srimati Vasanta so-and-so, letter dated 23/5, whose mining activities at a distance of 15.5 kilometers from KRS Dam is not blasting activity, but only light shipping to use black granite stone, has requested to allow such activities to continue without involving huge explosives. Two more ones. Then not at the bottom. Professor Muthu Shekhar expressed his opinion regarding above representations that as the matter is under trial in the Honorable High Court, this committee has limitations to comment till a verdict is passed in the court. All members consented.
May I
So
make
the
one
next result,
submission?
my lord, is by virtue of this interim order, in a proceeding to which I am not a party, entire, my lord, area, complete stoppage of mining activity is going on. I can understand, my lord, if somebody is using any blasting technology. The mining lease in my case specifies that I will only extract without any blasting, without explosives at all. So, my lord, that is may be permitted, my lord.
This committee is considering the individual grievances, or it is a general terms of reference?
They are not considering them.
Not
They may be directed to consider.
May I, my lords, kindly make one submission?
Yes.
My lords, the committee would be, in fact, obliged to consider my learned friend, Mr. Naganand's client's application. The reason I say that is, my lords, your lordships have passed an order dated 28th March 2024 in a connected writ petition that is 5990 of 2024.
Correct.
That order is in your lordship's file, my lords. Please permit me to just read two paragraphs in that order. The challenge there to, my lords, was to notices directing stoppage, my lords, of quarrying and crushing activities, as your lordships get in para 3. The challenge is advanced to the aforesaid notice raising various grounds. The notice requires the petitioner to temporarily stop quarrying, crusher, and other concerned activities within 20 kilometers radius of the KRS Dam, Mandya district. The notice refers to the order dated 8/1/2024, passed by a coordinate bench of this court, that is your lordship's present petition. In the said order, the court has required to stop the crusher, quarrying, and further concerned activities within the radius of the dam. Then the directions are quoted, my lords. Please come to para 4. Besides that, the notice to the petitioner is to stop the quarrying and other activities is based on the aforesaid order. the learned amicus invited attention of the court to the aspect that the state-level dam safety committee has already been constituted and is functional. It is a committee constituted under Chapter 4 of the Dam Safety Act. Section 11 deals with the constitution of the State Committee on Dam Safety, whereas Section 12 provides for functions of the State Committee. It was undisputedly stated before the court that the committee is seized of the very subject matter and the related aspects. It was further stated that the committee has been addressing the issue as to whether, in addition to the mining and crushing activities, which activities could be said to be falling under the category of allied activities, which would cause and would have a tendency of causing danger to the dam site and the safety of the dam. The very grounds mentioned in the notice are the centripetal issue, which the state-level Dam Safety Committee has been considering. The learned government advocate, in support of the notice, submitted that all activities potent to cause danger to the dam site should be classified as allied activities. It is for the committee to take a decision on this score. In light of the above, the writ petition is not liable to be entertained. It is open to the petitioner to approach the committee by way of appropriate application to seek consideration of his case and the grievance in accordance with law. The committee shall take into consideration all aspects, including the aspects which may be raised by the petitioner, to include the same in the report to be submitted to the state government. And therefore, my lords, if there is no element of, my lords, crushing or otherwise which is likely to in any way, or blasting, my lords, which would in any way endanger the dam, the committee may certainly consider my learned friend's application notes and pass an appropriate finding in its report and place it before your lordships. In fact, my lords, I have asked for the report within 10 weeks as per an earlier order dated 5/3/2024. 10 weeks time was given, my lords, which has since expired. And therefore, in the report, my lords, all aspects, including this aspect, my lords, could be referred.
So 10 weeks is getting over when?
That is so far as trial blast is concerned. Now it is the decision of the state dam safety committee that they are going to conduct mathematical modeling and proper validation. It is an alternative method of testing the vibration.
So the individual complaints or applications, my lord, as my learned friend Mr. Sondi has just now pointed out, they have to look into it. They can't say matter is pending in court, we won't see. I have filed an application, my lord, in WP 3339, which is before your lordships today, in the disposed of writ petition, where my prayer is that I have submitted an representation. Let that be considered within 2 weeks or some time-bound frame. That is my prayer, my lord, in a separate IA file. Because your lordships disposed of my application, writ petition, and in that, my lord, I have now filed an application.
So what is this writ petition for, this main petition?
Lord, main petition is, Lord, they are seeking.
Conversion of the land. The condition is imposed by the deputy commissioner only after the trial blast.
Page number 28, para 8. Page number 28, para 8. Till the receipt of trial blast report, land cannot be used for non-agriculture purpose. They have sought for alienation of land from agriculture to non-agriculture purpose for quarrying activities. The deputy commissioner rejected their application on this ground.
It is not rejected, my lord, it is granted that he said it will come into operation after the trial blast is
The trial
conducted.
blast is.
My lord, at 95(9), my lord, is a deemed grant, my lord. Once the application is made, my lord, the permission is deemed to have been granted. My lord, this writ petition, my lord, is treated as the public interest litigation by this court, directed that no quarrying activity shall be conducted in 20 kilometers. My lord, your lordships have not specifically directed, my lord.
10 week is getting over.
10 week is getting over. My lord, now.
Report will be out. Report of the committee will be available.
Now they are not, they intended to conduct trial blast. They have digged the holes also. At that point of time, there were agitations in and around Mandya by the farmer organization. Thereafter, my lord, that the minister, concerned minister held a meeting, and the state dam safety committee conducted a meeting and look into the aspect, and thereafter they have decided to conduct an alternative method of my lord, testing the vibration. Now it is contemplated to conduct, my lord, the mathematical modeling and the proper validation process.
With your lordship permission, IA number 4 is filed by me, wherein even my activities also do not involve blasting. And in the previous hearing date, your lordship has directed us to give a representation to the committee to assess what kind of technically what is
Committee is
and they are not even considered my application.
committee
Till today.
dealing
Because
with
it
this.
is seized off by your lordships, they are not considering. That's what they say in the today's report. They say, though your lordships had said we must give representation, they say in this report, because the honorable court is seized of it, we are not deciding.
Where is that?
Page 29, my lord, in the today's report which my learned friend just placed. Page 29, they refer to 3 representations. First
Last
one is
para
mine.
of 29, that may be
Last
clarified.
para, Professor Muddu Shekhar and member so-and-so express his opinion regarding above representation, that as the matter is under trial in the Honorable High Court,
That may be clarified.
this committee has limitation to comment. And your lordship said that they must consider neither the report of the committee is,
So we dispose of the very petition. This petition.
please, ma'am.
We are not entertaining. We'll say that the committee is free to look into.
Please.
And as far as your case is concerned, within 4 weeks or so.
Please, great.
Okay.
Case notes the interim.
That in writ petition 19,835 of 2023, I have produced the report, my lord, National Institute of Rock Mechanics has already conducted the scientific
No,
study.
that is for the state dam safety committee to decide, my lord.
My lord, may I submit, my lord?
What is your prayer here in this?
My lord, I have sought for that deemed, kindly see, my lord, the writ petition, my lord. Annexure A. Condition number 8, my lord. Page 28, my lord. Till the receipt of trial blasting report, land cannot be used for non-agriculture purposes. You are bound by the decision of the, taken by the competent authority on the basis of the report submitted after conducting a trial blasting by Kaveri Nira Limited. Under 95(9), millet, I make an application for grant of permission for use of the properties. Millet is an automatic grant, millet. This court, millet, in fact, they rejected it earlier. I filed a writ petition before this court. This court, millet, allowed my.
This may be disposed of, my lord, subject to the decision of the
Committee, we'll set down the time limit of the committee, we'll
Yes,
clarify that. Now there will be no petition pending, therefore committee will be proceeding independently.
Yes.
The excuse will
The
not be
lordships
held.
will be keeping the main petition pending. my lords.
Individual representations also, my lord, they have to take a call.
Please.
So there may be a small unit which is not using power also.
Yes, Mr. Sanghi, it is
The main petition your lordships would be keeping pending.
pending.
Grateful, grateful.
Why pending?
My lords, the main petition is where your lordships have passed the order on 8/1/2024, noticing, my lords, the importance of the KRS dam. If your lordships kindly see para 7,
8-1.
please. After referring to the various reports and statutory provisions, etc., please see para 7.
Oh, 8-1, yes. There are 7. It is by coordinate bench.
Please, my lords.
Yes.
Grateful, my lords. The KRS dam has a unique heritage and great historical value attached to it, principally for the most valuable contribution made by a great son of this country, Bharat Ratna Shri M. Vishweshwaraya, the chief architect of the dam, and enormous contribution of the great visionary Maharaja of Mysore, Sri Krishnaraj Wadiyar. The dam is described in the literary work as the creation with blood and sweat of the people of old Mysore state. We deem it appropriate to protect this dam from any activity potentially dangerous to its safety and existence. We do not concede to the submission of the learned counsel for the petitioner that his client should be permitted to carry on the mining activity sans blasting. Admittedly, the petitioner's mining area is within a radius of 20 kilometers from the dam site. His submission that in several similar cases, authorities have accorded mining permission license and that this court too has granted relief to the miners in the very same region may be true. However, kindly mark this, my lords, all those cases had arisen before the enactment of the 2021 Act. Even otherwise, being the custodian of public property, the constitutional courts cannot turn an Elson's eye to the possible danger by damage posed to the dam of this size. We need to take all steps that are required to prevent the possible damage because of mining activities. The enormity of public interest involved in this petition filed by an individual for private relief does not come in the way of us treating the same as a PIL petition, White State of Uttar Pradesh versus Neeraj Chaube, 2010 Supreme Court. We need not state that the apex court time and again had treated even a postcard as a social action litigation. And accordingly, my lords, the directions were issued after para 9. And these are the directions that are protecting the dam, my lords, from any action. Therefore, my respectful request would be,
So
since
it
there is a
treated as-
larger...
It is treated as PIL.
Yes, my lords, it's been treated as a PIL. And therefore, your lordships may consider keeping the petition pending. Let the report of the committee, my lords, come before your lordships. The committee will also take the matter seriously if the matter is sub judice. I'm only submitting as the amicus, my lords, so as to preserve this heritage property.
That your lordships, my lord, in the same order, your lordship, para 5 of that order, my lord. If any difficulty arises in giving effect to these interim orders, any person concerned can move this court, seeking appropriate orders. Similarly, after the study and research report is submitted to the statutory committee, it is open to the parties to move the matter. That your lordships intended, my lord, to protect the dam where the blasting materials are used. In my case, my lord, the connected case, my lord, is a crusher, my lord. We get the building stone 20-25 kilometers away and carry on crushing activities where no blasting activities involved. My lord, by this process, my lord, several thousands of people have lost their employment. And in addition to that, my lord, we are required to pay various incur expenses on day-to-day basis, my lord. Employee salary, minimum electricity bill. My lord, so far as this interim order, my lord, my request to your lordship, clarify, my lord, it's confined to the where blasting it is used. Where there is no blasting used, my lord, in fact, Dharat Senior is appearing on a connected matter, there is a condition wherein, my lord, they are prohibited from using the blasting material. Even in such cases also, my lord, if there is a prohibition, it really, my lord, causes a lot of inconvenience to those who are dependent on the livelihood. That's the reason, my lord, at para 5, your lordship directed the parties, if there is any difficulty, please come and approach this court.
Your IA is 7 of 24.
Yes, there are two applications for all. In 19835, IA 6 is for impleading.
6.
Yes. IA 7, my lord, is for clarification.
So that is main IA, verification.
Yes, clarification is clarification of your lordship's order, my lord. Two directions had been given.
Verification of which order?
In WP 3339 of 24.
3339.
Yes, 3339 of 24. Your lordship said in that writ petition by disposal permitted us to remove the mined blocks already kept there.
Disposal.
It's a disposed of matter. Your lordships had given two directions.
Where is the order?
The order, my lord, is part of the IA. Is 2nd April 24.
So this IA you filed in the present procedure.
Yeah, this is
How?
in 3339, that is the one, my lord, which your lordships have disposed of. There were two directions your lordships had permitted now.
No, the IA by you is filed in which process?
That is, my lord, in 3339.
3339.
Yes. In
Okay.
3339, your lordships had permitted two things, Lord. One, permit us to give representation, committee to consider. Two is for me to remove the mined blocks. So your lordships had set a time limit. So my request was to give that extension of time for removal. And second one is for a time limit for the committee to take a decision.
That can be done. So this IAS will be disposed of accordingly. And as far as the other main matter is concerned, where Mr. Sanghi is amicus curiae, we'll clarify that the committee will be at liberty to decide all individual applications and the observations will set aside in the order, or we'll say clarify the observations that the committee will not be fettered by the pendency of this. And we'll also time limit set down for committee.
Please.
Already 4, 5, 6 months, my lord, everything is at a standstill.
So as far as you are concerned, Mr. Nagananda, this order is to be clarified.
Yes.
Tomorrow at 11 will pass the open court.
Grateful.
Good.
This was by a different bench.
But my lord, this is a further order, my lord. After a matter is disposed of, there was a time limit that was fixed. That order, my lord, your lordships, my lord, I respectfully submit, can be, any bench can pass it, my lord, because it's a time limit fixed, your lordships are fixing a time, that's all. Extension of time like under section 152.
We'll see tomorrow. Let it.
Please.
ಮ್ಯಾಟ್ರ್ ಮಾತ್ರ ಇದು ಇದೆಯಾ ಇದು ಬರುತ್ತಾ ಇದು ಈ ಮ್ಯಾಟ್ರ್ ಬರುತ್ತಾ
Keep it tomorrow.
Grateful.
If clarification is made in the main, this present matter, this 19835,
Can be made in this also.
it can take care of your.
Yes, yes.
And there is one more
Because
application
now
is
that
also
my learned
pending.
friend has filed a report, in the report, they're referring to my representation. And their observation that their hands are tied, that's what they think. In this, if your lordship clarifies, that is.
Please.
May I make one submission? Yeah. Serial number 30 in the my lord orders, contempt list. On 27/6, my lord, the accused have taken time, my lord, to comply with the order. 10 years, my lord, litigation, my lord, goes back. Your lordship said, my lord, they will comply within reasonable time. Till today, though 1 month has passed, they have not complied. The revision of.
What is to be complied with?
Revision of pay scales, my lord, they have to, or they may be directed to be present or they may comply. Serial number 30.
When do you want?
Number 23. On Monday. They may comply or they took time, my lord. They only voluntarily said they will comply with the order.
Monday.
Lordship, serial number 50. This is writ appeal numbers 969. This is a direction of your lordship to the NCLT. Dispose of matters by 31st July. So this is an application seeking to extend that timeline.
Give
Here,
you there. Serial number?
serial number 50 and 58. In writ appeal number 969 and 972, your lordship.
Let us see what is it.
My lord, serial number 23rd.
Wait.
Just wanted a short extension.
I appear in that matter. But, we were the respondents in that matter, and your lordships had directed disposal by 31st. But in the interregnum, another petition, my lord, for corporate insolvency was admitted against the company. Your lordships were considering a petition for operation and mismanagement, and the moratorium kicked in.
Both sides are here.
We are not granting the extension. The propriety requires, according to us, that the NCLT should come, not the party.
But of course, there may be one difficulty now for the order itself to be passed, and that is the fact, not that under the IBC code, on a petition filed by one of the operational creditors, the company has been introduced into corporate insolvency resolution. Therefore, the moratorium under Section 14 has kicked in, and therefore no order can be passed against the company today. All proceedings against the company, my lord, will come to a stop.
But
No, in fact, my lord, that order which has been passed by the NCLT in the IBC petition, my lord, that is the subject matter of a challenge before the NCLAT.
We
The
know,
proceedings
Mr.
were deferred
Chinnappa,
from-
the point is that when the NCLT is given time to dispose of the proceedings, and the
Yes.
time is to be extended, it is for the NCLT under supervisory jurisdiction of this court to come before the court through the registry and request, not by the party. That is the consistent view I have taken throughout my career as a judge, that
My lord.
any direction given to subordinate court
Yes.
or district court regarding time limit to complete the proceedings cannot be extended unless the
Very well. My lord, in
court
that case,
or body comes.
Yes,
my lord, in
Not at
that
the
case,
instance, not at the instance of party to the proceedings.
very well. My lord, may I beseech my lord's indulgence only to a limited extent, that my lord may defer this application. We shall, my lord, request before the NCLT to, my lord, forward the application as my lord has just directed. Please keep this application pending for a
Either
week.
by way of a communication to the register
Yes.
of this court seeking extension, or by way of
Yes.
whatever
Yes,
means.
my lord may just defer the adjudication of this application by a week or 10 days. My lord, we shall make a request before the NCLT tomorrow itself. We'd apprise the NCLT today. That's why the NCLT has adjourned the matter. We shall request it tomorrow, my lord. Please defer this adjudication by a week or
This may
10
be
days.
deferred for 10 days. 10
I'm
days.
so grateful. I'm so grateful.
My lord, serial Serial number 23rd, contempt petition, my lord, it is more than a year. They have not complied with the single judge of order.
Pardon?
Contempt petition, serial number 23. Respondent have not complied with the single judge's order, even after more than a year, my lord.
20.
1042.
Writ appeal has been filed, my lords. 980 of 2020.
Writ appeal is filed, to be listed with writ appeal.
Please.
If your matters are not reached, I think we'll also be giving it.
Today it is not,
Someday
today
it
many
will
matters are not reached, so we'll be distributing as per the urgency. Give the dates.
Mhm.